They prayed for at least 2 weeks' time to produce the report.
That is that matter, no?
Yes, Lordship, habitual of dismissed from service.
Oh, habitual offence.
Yes. The unit is now in Manipur, Lordship, so they pray for some more time, Lordship.
The SS Roy, the learned counsel appearing on behalf of the respondents. Submits that the records which were directed to be produced could not be produced today, taking into account that the unit is presently at Manipur. And as such, submits that he requires some more time. List the matter again on 29th of August.
Lordship.
May I please?
Oblige, Lordship.
I beg to mention item number 12, ma'am. I'm feeling some personal difficulty, ma'am. Suffer my cold and fever, ma'am. So I cannot.
Item number?
12, madam.
Why?
I am suffering for cold and spoken for could not speak properly, madam.
Huh?
I am couldn't speak properly.
Matter pertains to what?
Relates to my lord, public remedy outrage of occupation act.
Don't worry. You don't need to speak. We'll take care of. No idea. Next.
I pray for listing of a matter. It's an eviction matter, Lordship. Notice is being served on 31st/7, Lordship.
Mention it before, Justice Sham.
Lordship,
You mentioned it before, Justice Sham, court number 5,
there is a notification, Lordship,
regarding what?
regarding for my non-appearance before that,
Oh,
Lordship.
when do you want it?
Tomorrow, Lordship.
What?
Tomorrow, Lordship.
What is the urgency?
Because eviction matter notice is served on 31st/7, Lordship. And it's a legally. Matter.
It's a motion?
Yes, sir.
We'll take it up today. The urgent matter, we'll
Yes,
take it
sir.
up today.
Yes, sir.
At number 1,
One. This item has been allotted to Mr. Goswami. Let he prays through me, my lord. Let the matter come up at 2, my lord.
Hmm?
Let the matter come up at 2, my lord.
What is that matter?
This person, my lord, he alleges, my lord, is representing a minor. This minor was, my lord, illegally detained by the police in the Karbi Anglong district, my lord, who is a juvenile and not produced before the board.
Then?
And now he seeks, my lord, compensation. One of his prayers, my lord. Compensation, basically, my lord.
Compensation, how much?
Well, there is a just 5 lakhs, my lord. Recently, one matter was there regarding custodial death, my lord. So it went to the tune of maximum of 5 lakhs.
What about the police?
And since this police is involved, my lord, I don't want to submit. My lord. Let the additional AG come, my lord, at 2 months. The matter be taken up at 2.
Hello, we'll take it up. This matter needs an early.
Yes, my lord, 2, my lord, at 2. My lord. Oh, let's man.
at number 2,
Yes, Mr. Bhattakur.
This is the case your lordship where the petitioners are paying for regularization of their services.
Regularization? Where?
In your lordship, initially under NIPCO, they were, initial appointment was under Brahmaputra board, your lordship. There the Brahmaputra board, the project was taken over by the NIPCO. So their services have also been taken over by the NIPCO, your lordship. Then they are as a casual workers, they have been continuing till date. In the meantime, your lordship, on last, they have submitted that this was again taken over by NTPC, your lordship. Therefore, we are directed to make NTPC party. We filed petition, your lordship, imprisonment petition. Then NTPC was also imprisoned as a party respondent. Then matter is at that stage, your lordship. They have entered FPA.
What is this memorandum of undertaking?
This is the memorandum of undertaking is between your lordship Brahmaputra board, your lordship, and the NIPCO, your lordship, regarding the taken over of the Tipaimukh project, your lordship.
Show me that, which is the clause by which they are going to.
Will kindly come to page. Your Lordship will kindly come to page 20, next page. The
Yes.
CMD agreed to pay the salary and wages of existing workshop casual staff along with the subdivisional staff deployed at the department of maintenance of the existing assets till formal handing over of the project. The expenditure to this effect is estimated about rupees 5 lakhs. Then your Lordship, clause 5. CMD NIPCO stated that clearance of the project by PIB after other statutory clearance will take time. The construction activity can be started after that only. I assured that the Brahmaputra Board engineer, other staff will be taken as and when PIB clearance is received by them as per requirement of the project. Recruitment will be done plus phase manner in consultation Brahmaputra Board. Engineer agreed to write to the Brahmaputra Board. Then your Lordship, for seeking Epson's willingness of their employees so that their transfer could be decided after completing all the required formalities. The selection and appointment will be done by NIPCO in consultation with Brahmaputra Board, initially on deputation basis leading to permanent objection. However, it was felt that taking people on permanent basis would be in the interest of both the organization subject to recruitment policy. Then your Lordship may kindly come to next page, your Lordship, page 22. This is the minute of meeting. And page 23, your Lordship, clause B of this minutes of meeting. The list of casual workers engaged against the Paimuk Dam project during pre-construction works as well at present comprising of 48 number of workers were also shown to the team from NIPCO. The name and address of only 14 numbers of this list of casual workers who were physically working at Tipaimuk as on so and so were noted down by the team of NIPCO. We fall within this 14, your Lord. Now, your Lordship, 6 left, your Lordship, and 6. By the time we prepared this read petition, 6 were left out of those 14. Out of those 14 casual workers who were taken over, your Lordship, 8 has your Lordship left. Only 6 remain, they were still working. Your Lordship.
Now the regularization has to be done by whom?
Your Lordship, initially it was our claim was against NIPCO. Now they say that since it is now NTPC has taken over the project. So it will, NHPC has taken over the project. Therefore, it will be NHPC only.
Now tell me whether the NHPC will be bound by what the Brahmaputra Board has stated.
Lordship,
This is just an observation, however, they are required.
Lordship, they
There's
have
nothing out there, there is a commitment, there is anything to that effect.
Lordship, so far as these people are concerned, there was a memorandum of understanding on the basis of all the employees of Brahmaputra Board who are working in the Tipaimuk project, both regular and casual were taken over by the.
Where is that?
Your Lordship will kindly come to this, your Lordship. Page 22.
22 does not say anything to the effect that they will have been taken over. They are still, they will be regularized or given on permanent
not
basis,
regularized.
nothing. But your prayer out here in
My
the
prayer is,
petition
your
is this.
Lordship, since your Lordship will kindly see, they have taken over my services as a casual employee. We are working, your Lordship, till date, your Lordship. And your Lordship, they have, your Lordship, utilized our services, extracted our services, your
But
Lordship.
how can this court grant direct regularization?
Your Lordship cannot, your Lordship, as such, your Lordship. But your Lordship, there is one aspect of the matter, your Lordship. Your Lordship will kindly know that your Lordship in Umadevi also, your Lordship, which has virtually barred your Lordship the regularization of service on the direction of this honorable court, your Lordship, or honorable court, your Lordship. They are also, your Lordship, in para 53 of that particular judgment. There is an exception, your Lordship, number 1, your Lordship. And subsequently, that has been explained in ML Kestri's case, your Lordship. Then what will be that exception, your Lordship? And apart from that, your Lordship, there are other judgments, your Lordship, like your Lordship, Nihal Singh and others, your Lordship, which have somewhat, your Lordship, diluted that Umadevi's, your Lordship, dictum, your Lordship. So, your Lordship, under that circumstances, your Lordship, since that one-time exercise that was required to be carried out by the NHPC, your Lordship, NIPCO, your Lordship, that has never been carried out by them, your Lordship. So
You see, Uma Devi was a judgment where the constitution bench at the last moment at paragraph number 53 say that those people who have been working out there for the 10 years out there and without on the not on the basis of any interim order, they should not be disturbed.
Lord,
Meaning thereby those people who have been illegally regularized should not be disturbed if there is no interim order to that effect. Because there it says that the question of on the base, some people have been regularized and the aspect is whether regularization can happen if it is an illegal appointment.
no, Your Honor, so far as our case is concerned, we are not illegal appointed.
Absolutely, there's no question on that. But the question involved out there was
Yes,
if there is
Your
an
Honor.
illegal appointment,
Yes,
there can be a case of there some at that point of time there has been a lot of regularization which was done.
Lordship done.
And as
In
such,
that
the
view of
Supreme
the-
Court says that no, nothing doing out there as regards regularization. You can't, but those people, however, have been working for the 10 years, don't disturb them.
Not only Your Lordship, don't disturb them, Your Lordship, in my, with due respect, Your Lordship. That also says that there should be a one-time exercise by the authorities, Your Lordship, employers, Your Lordship, so far as the people who are casual workers or ad hoc workers or workers, employees or master role workers, etc. And that has, Your Lordship, if Your Lordship go.
Let's read paragraph
Sure.
53. Madam Chaudhary, has any report been submitted in your case?
In fact, I have just received a message from that, the lady pediatrician. She sent a message saying that they'll be convening the meeting tomorrow, day after tomorrow. On 10th at 3:30 PM, they have fixed the first meeting. In fact, my learned friend, Mr. Gogoi, I've been pressurizing him. Mr. Gogoi told me that because of the fact that the counseling and all was going on pursuant to the NEET examination, therefore the DME could not fix up the timing. Now, supposedly, I just received the message that at 3:30 they'll be sitting day after tomorrow, and they've requested the papers. Your Lordship.
Its message is how? SMS.
It's in, I don't know how she got my cell phone number. It's through a WhatsApp message, Your Lordship.
We do one thing. We record that. Let Mr. Gogoi come.
Let Mr. Gogoi come.
Let's record it
I'm here, Your Lordship.
and then ask them to complete as early as possible.
My only prayer is that it may be taken up during the month of August itself, Your Lordship. Let them complete the inquiry. I'm sorry. Let them complete the inquiry within the month of August, Lordships, because it's been almost more than 9-10 months now that this matter has been pending only for that particular report. So therefore, let Mr. Gogoi come. I'll call him, Your Lordships. I'm here. I'm at Your Lordship's disposal.
We'll see.
Sure.
Yes, let's see, Uma Devi. Uma Devi, what is the citation?
2006 4S51.
For SCC?
1.
In fact, in 2017 or 18, the judgment of the Supreme Court in the case of State of J&K versus District Bar Association Bandipara, that also clarifies that aspect,
Sure.
only to the extent that the court doesn't have the power. But the authorities have a power, they can very well do it.
In fact, Your Lordship, full bench of this honorable court, Your Lordship, while deciding it to Your Lordship of Shiksha Mitras, Your Lordship, have also said that there should be in such circumstances scheme, your lordship, by the state government to to regularize the service or to give the benefit of the.
But Mr. Botago, this court can very well suggest the government, the authorities may have a scheme, but the court cannot have the power.
Correct.
Let's see paragraph 53.
May I read, your lordship?
Yes.
One aspect needs to be clarified. There may be a case where irregular appointments, not illegal appointments, as explained in S.P. Narayanappa and R.N. Nanjudappa and B.N. Nagarajan are referred to in para 15 above of duly qualified person in duly sanctioned vacant post might have been made and the employees have continued to work for 10 years or more without the intervention orders of the court or tribunal. The question of regularization of services such employees may have to be considered on merits in the light of the principles settled by this court in the cases above referred to and in the light of this judgment. In the context, the Union of India, the state government and the instrumentalities should take steps to regularize as a one-time measure the services of such irregularly appointed who have worked for 10 years or more in duly sanctioned posts but not under cover of orders of the courts or of tribunal.
But were you appointed against duly sanctioned post?
Lordship,
It can't be
for-
sanctioned post if you were casual.
Casual employees, your lordship, but your lordship, ultimately, your lordship will kindly see. They have continuing in some capacities, your lordship. And therefore, your lordship will find in subsequent judgment, your lordship. Even your lordship, in case of this casual employees, your lordship, that direction is there. It is your lordship, one case, your lordship. In
But here in this case, it was a person who have been appointed on casual basis
Sure.
in a duly sanctioned post.
that is there. Your
That is
lordship.
Umadevi.
Sure.
Then in that case, you can consider because it is on a particular, because otherwise what will happen? If there is no sanctioned post out there and a one-time measure would be directed, then in that regard, it will be directing the authorities to create posts,
Sure.
which would absolutely be within the administrative exigency of the state. So that this court can't do it.
Sure.
But if it is in sanctioned post, a person has been working on a casual basis or on a temporary basis, they can very well be considered taking into account that they've rendered for 10 years. Just in the case of Dolly Borpujari,
Sure.
where there is a case where this person, although there was a sanctioned post out there, but she has been kept on a contract basis. So as such, the pension was also granted in that case by the division bench. Now let us see, you have the judgment of District Bar Association Bandipara.
District bar association, your lordship, I don't have, your lordship, but others, yeah.
You see that because that is the later on the point of time, how everything has been duly taken note of. It has been to Ulai Dioksun Pyong. But the judgment.
Your lordship, if your lordship permits me, your lordship, if your lordship go to 2010 9 SCC ML Kesri, your lordship,
In fact, that has been duly taken note of in this judgment.
lordship. And in ML Kesri, your lordship, these were the daily wages, your lordship. The case of daily wages, your lordship. Don't put that. Yeah, today. no. Binding to nothing.
'Do you have the citation of district bar association?
Your lordship, 2017 PSC 410.
Seventeen, three.
3 SSC, your lordship. 410.
Do you have a copy of it?
I have your lordship.
Era ulaidia print out the
17 3 SSC.
In fact, there are so many judgments, but the concept of regularization, this has been more pinpointed out. And this is the first judgment of a kind where you find the clarity as regards what is the concept of regularization. Wherein the Supreme Court says that regularization is not a source of recruitment. See, paragraph 11 of this judgment, the decision in Umadevi 3, paragraph 10 takes into account what are the two issues. The decision in Umadevi dealt firstly with the right claimed by the temporary employee to be regularized in service on the basis of long, continuous, legitimate expectation employment under the state and the directive principles. The second salient question which the Constitution bench was called upon to answer was whether the court would be justified in issuing directions for regularization based on such features such as equality and long spells of service. On both counts, the Constitution bench held against the temporary employees. However, in Umadevi is not an authority for the proposition. The executive or the legislator cannot frame a scheme for regularization. Umadevi 3 does not denude the state or its instrumentalities for framing a scheme for regularization. That reference was made to paragraph 53. Now, kindly see paragraph 12. The third aspect of Umadevi which bears notice is the distinction between irregular and illegal appointment. While answering the question as to whether an appointment is irregular or legal, the court would have to inquire as to whether the appointment adopted was tainted by the vice of non-adherence to an exception so and so. We are not concerned about that. But the fact as regards which have been explained in paragraph number 11 of this judgment, which gives whatever, because here thereafter Umadevi, various judgments have also been discussed. Then you find here again, renew and all these things have been there. Four fundamental principles, paragraph 16. This is on here. four fundamental principles emerge from the decision of this court in Renu. The first principle is that 235 enables the High Court to exercise complete administrative control over the district, which extends to all functionaries attached to this court, including the ministerial and the employees. The power of superintendence would be frustrated if the so-and-so. The second is that employment in the High Court of so-and-so, we are not concerned, likely to occur. Fourthly, the is an autonomous so-and-so. The following directions were passed. Now, paragraph number 21 says the difference between irregular and illegal appointments is also the scope of paragraph 53 of Uma Devi has fallen for consideration in various subsequent judgments. So there the judgments have been referred to. Lalit Kumar, so and so, so and so, so and so. Now kindly come to paragraph 26. Ekon Didi. Kindly come to paragraph 26. The principles will have to be formulated bearing in mind the propositions set out in the aforesaid judgments. Regularization is not a source of recruitment, nor is it intended to confer permanency upon appointment which have been made without following the due process envisaged by Article 14 and 16 of the Constitution. Essentially, a scheme for regularization, in order to be held to be legally valid, must be one which is aimed at validating certain irregular appointments which may have come to be made in genuine and legitimate administrative exigency. In all such cases, it may be left open to the court to lift the veil to inquire whether the scheme is aimed at achieving the above objective and is a genuine attempt at validating irregular appointments. The state and its instrumentalities cannot be permitted to use this window to validate illegal appointment. The second rider which must be necessarily be placed is the principle as formulated above is not meant to create or invest in a temporary or a ad hoc employee the right to seek a writ commanding the state to frame a scheme for regularization. Otherwise, this would simply re-evaluate a class of claims which have been sought out permanently by Uma Devi. Ultimately, it would have to be left to the state and its instrumentalities to consider whether the circumstances warrant such a scheme being formulated. The formulation of such a scheme cannot be accorded the status of an enforceable right. It would perhaps be prudent to leave it to a claimant to establish whether he or she falls within the exceptions carved out in paragraph 53 and falls within the ambit of the scheme that may be formulated by the state. Subject to the riders referred to above, a scheme could fall within the permissible limits under so and so. So here you see, this court cannot even direct them to have a scheme. But, however, taking into account that we have been working for all this while, a legitimate expectation may accrue upon you for the purpose of considering your case for regularization, which the authorities may. That is the only thing.
That is it.
But this court can't direct anything,
That's I understand. Your Lordship.
and it is not an enforceable right.
Your Lordship.
You can very well represent before the authorities, and the authorities may take a call on this as to whether to have a scheme or not. I can't direct anything.
Now, if Your Lordship read Your Lordship 53 and this judgment together, Your Lordship, para 53. In my
Para 53 says about sanction posts.
No, Your
And this is the last of the judgments in regularization.
this is the
Because what has happened out there, that the Jammu and Kashmir High Court had directed regularization of those people who were working in the district court of Bandipara. Then the matter came up that how can you do so? The state of J&K came before the Supreme Court and said that you couldn't have done it. And there's no enforceable right. It is under such circumstances these have been observed.
And if your lordship read
Kindly see paragraph 30 of the said judgment.
particular,
30.
we have already indicated above our conclusion that the direction for regularization was issued by the High Court without considering the relevant constitutional and legal principle. While some of the daily rated workers have been engaged over a long period of time, others have been engaged as recently as in 2015. The issue is whether such appointments are irregular or whether they were illegal should have been determined but has not been considered. Since the issue of regularization is a matter with which the state government is seized as stated in the proceeding before this court, we are of the view that at this stage it would be appropriate and proper to set aside the interim order of the High Court which directs regularization en masse of 209 daily rated workers. While doing so, we restore the proceeding back to the file of the High Court for reconsideration. We order accordingly leave it to open to High Court to reconsider the entire matter expressed, having due regard to the constitutional and legal principle in which
This has been referred back to the High Court only for the purpose in the administrative
Sure,
capacity,
sure.
not on the judicial side.
Sure.
And paragraph 29 also, if you may see, we have also averted to the above grievances in order to emphasize there is a substantial merit in the submission of the High Court procedure.
Regularization without considering either of the legal position enunciated in judgments of this court referred to above and without considering the prevailing rules and regulation of the subject. The High Court has observed in its order dated 1/12/2015 that over a considerable period of time, the state government has not created the required number of posts for the state judiciary, as a result of which work has been hampered. According to the High Court, appointment of daily rated workers was necessitated to ensure that judicial work does not suffer. The High Court opined that those workers have been rendering work which would have been assigned to persons appointed on a regular basis against Section 4. It is unfortunate in our view that the state government has allowed the requirement of the state judiciary to be neglected over such a long period of time. The need to facilitate proper functioning of the High Court and district judiciary is a constitutional necessity which imposes non-negotiable obligation on the state government to create an adequate number of posts and to provide sufficient infrastructure. The state government is to blame for the unfortunate situation which has resulted in large number of persons being recruited on a daily basis.
So these were the observations which were there. So under such circumstances, it becomes very difficult for this. And I would have understood if there was any agreement on the basis of which you are claiming, it's a different thing. But there seems to be no agreement for that.
No, no such agreement, Your Lordship. They say, Your Lordship, that we have taken them over service of these petitioners.
No, they have taken you as a casual worker.
Casual workers, that there was no agreement as such for regularization, Your Lordship. That is there, Your Lordship. But my claim is, Your Lordship, based on this, Your Lordship, and my humble submission would be, Your Lordship, even if we read all these judgments together, it is the duty of the state even to frame a scheme, and under that scheme, Your Lordship, whether we fitted into that. scheme or-
Understood, whether it is a duty or not, that has been answered by that in
Yes,
Bandipora.
yes.
That
Para 20
framing of a scheme is not an enforceable right of
Right,
this.
right.
And as such, the court cannot direct.
Lord.
Yes, madam, tell me, or have I argued on your behalf?
And Your Lordship may kindly also see that full bench judgment of our High Court, Your Lordship, on Shiksha Mitra, Your Lord. Although Your Lordship, that is
Ulven's judgment of the High Court, with due respect,
Lordship,
is there, but those judgments of the Constitution Bench and the Supreme Court, I think, overrides everything.
no, I accept that, Your Lordship.
Because what is the problem which is happening? Just for example, let me tell you an example of Upendas. Upendas, the court has given anybody who has been working for 10 years, you give them the minimum of the scale of pay. This has been done on the basis of Jagjit Singh.
Justice.
But Jagjit Singh did not fix a time limit. But here it has been done. Now what we see, as I was taking the pension bench or the area salary bench, the authorities have only taken 8/6/2017 as the gospel date. But have not. Just for example, a person may have 10 years in 2019 or may have in 2021. That is not being applied. But the principles on which it was done was Jagdish, which says that if you are working the same thing, you are entitled to the minimum of the scale of pay. That is the issue which was there.
I have your lordship as an alternative prayer. I have also brought the.
Yes.
And in fact, why I am referring to this full bench judgment, your lordship, because it has also taken note of this state of Jammu Kashmir. And after that, your lordship, they directed to, this honorable court directed to frame a scheme, your lordship. for-
How can this court direct?
Lordship,
No,
that is why, your lordship,
when the state of Bandipora categorically says that the High Court can't direct, how can this court direct? Tell me. Unless the full bench can supersede the Supreme Court
No,
judgment.
your lordship, what your lordship. in-
You submit that, then it is okay. I hope you are not going to submit. And the full bench is also 3 judges.
Full bench is also.
And Bandipora is also 3 judges.
That has been referred to here, your lordship, in para 33.
Understood, but the problem is, have they taken note of this paragraph of 20?
It only, it is your lordship, may I read your lordship.
This-
Again, the case of District Bar Association Supra, it preserves bench of the Supreme Court, analyzed the decision of Uma Devi and highlighted the essence of this judgment. Supreme Court was of the view that Uma Devi dealt firstly with the right claimed by the temporary employees to be regularized in service on the basis of long continuance, legitimate expectation, employment under the state and the directive principles. The second issue dealt with was whether court should be justified in issuing direction for regularization based on such features. On both counts, Uma Devi held against temporary employees, but most importantly, it was highlighted that Uma Devi was not an authority for the proposition that the executive of legislature cannot frame a scheme for regularization. It was held that Uma Devi does not denude the state and its instrumentalities from framing a scheme for regularization. Then para 35. Viewed in this context, there is certainly an alteration of the legal position, firstly by the case of Nihal Singh, then by the case of Amarendra Kumar Mahapatra, and finally by the case of District Bar Association, that the state is not denuded of the power to frame a scheme for regularization of service of temporary or such category of employees. Therefore, there is a clear safety.
No, Mr.
legal-
Kotago, what do you say about that judgment who did not take paragraph 26?
Lordship,
I
26 has something of
I
effort,
think this judgment may help somebody
Lordship.
at some point of time. Why should I say that that has not taken care of 26 and hold it to be per input? Let us not do in this matter.
No, your lordship, what this honorable court also directed not to frame a scheme, your lordship.
Whatever may be, the
it says that-
question of framing a scheme does not arise. This court can't direct because it is the right of framing a scheme is not an enforceable right.
That's why this honorable court also not directed as such. It says, consider framing a scheme. It says last para 44, therefore having regard to the grievances expressed by the petitioners and the discussion made above, we are of the view that it would meet the ends of justice if similar benefit as granted to the master role workers, similarly placed employees working since last more than 10 years, is extended to 6 authorities. Accordingly, we direct the state to consider framing of a scheme for it.
Now here this 10 years has been taken. No problem with that. But those, as per Uma Devi, the 10 years is in respect to sanction post.
Lordship, but
Yeah.
your lordship, that Kesri slightly your lordship.
But how can that be by any other judgment when the constitution bench only gives one exception and that exception is only in respect of sanction post? Anyways, chalo. Anything, madam?
Lordship, this project has been transferred to the JV, so Lordship, any directions need to be given to NHPC, Lordship, not NIPCO.
You are not NHPC.
No, Lordship, we are NIPCO 2, 3 and 4.
Whether NHPC has been made a
Was
party.
implemented
Yes,
recently.
Ah, it is there. Who is appearing for that?
NHPC were implemented recently only, Lordship.
Huh?
Gautam Boyce's name is for.
Name is shown. Have you seen him around anywhere today? Anyways, I'm not passing an order against them, so the instant writ petition has been filed by 14 have been filed by six petitions. Seeking a direction upon the respondent authorities, that is NEPCO, to regularize the services of the petitioner in terms with the decision of the memorandum of undertaking dated 14/7/1999 with retrospective effect, and or not to transfer their services to NHPC authority, and or to stop all process of transferring the petitioner's service to NHPC. The facts involved in the instant writ petition is that the petitioners herein were appointed as master roll worker in between 1989 and 1995 in the Brahmaputra board, and were engaged as Tipaimukh Dam project. Pustak. The said project was handed over to the Northeastern Electric Power Corporation Limited, for short the NEPCO, on the basis of a decision by the central government. It appears from Annexure A to the writ petition that there was a minutes of the meeting between the Brahmaputra board and NEPCO in connection with the transfer of the Tipaimukh Dam project which held on 14/7/1999. In paragraph number 3, in clause number 3 of the said meeting, minutes of the meeting, it was agreed by the CMD NEPCO to pay the salary and wages of the existing work charge / casual staff along with the subdivisional staff deployed at the Tipaimukh for maintenance of the existing assets till formal handing over of the project. In terms with clause number 5, the CMD NEPCO stated that the clearance of the project by the, what is PIB?
PIB or project implementation board.
Of the project by the PIB after other statutory clearances will take some time. And as such, the construction of activity can be started after that only. The CMD NEPCO therefore assured the Brahmaputra board, engineers and other staff will be taken as and when the PIB clearance was received by them as per the requirement of the project. It was further mentioned that the recruitment will be done in phased manner in consultation with the Brahmaputra board. It was also mentioned that a selection and appointment will be done by NEPCO in consultation with the Brahmaputra board, initially on deputation basis, leading to permanent absorption. Further to that, it was also recorded in the said minutes that taking people on permanent basis would be in the interest of both the organizations subject to recruitment policy. Pursuant thereto, there was another meeting between the officials of NEPCO as well as the Brahmaputra board, which was held on 9/8/1999. It is however relevant to take note of that in the said minutes of the meeting, the transfer of personnel from the Brahmaputra board to NEPCO was also a point for discussion. Clause 1 of the said minutes being relevant is quoted here in below, is reproduced here in below. Paragraph page 22. Pabode. Clause 1, A, B, and C. First. It is further seen that the petitioners thereupon, the services of the petitioners thereupon was taken over by the NEPCO. And the petitioner continued to render the service. It has been also, now also they are serving.
Yes, sir.
It has, during the course of the arguments, this court had also put a specific query upon the learned counsel appearing on behalf of the petitioner as to what is the present status of the petitioners, taking into account that the petition was filed way back in the year 2011. The learned counsel for the petitioner, Mr. S. Bottakur, submits upon instructions that the petitioners still continue to be rendering service as
Casual worker.
casual employees. In the backdrop of the above factual matrix, the issue therefore, which have been raised in the instant writ petition is as to whether the petitioners herein, on the basis of the minutes of the meetings referred to herein above, would be entitled for a direction for regularization and thereby to be permanently absorbed in NEPCO. Ms. R. Stodi, the learned counsel appearing on behalf of the respondent NEPCO, submits that in the meantime, the said project has been now handed over to NHPC. What is that? National Hydroelectric Project. Huh? NHP Power.
National Hydropower
Hydropower
Corporation.
Corporation. That is the respondent number 5. She further submitted that she further submitted that at present, as the petitioner services are no longer retained by the NEPCO, no direction therefore ought to be issued upon the NEPCO. It is further relevant to take note of that by an order dated 35/2022, the National Hydroelectric Project, Hydroelectric Corporation, Hydroelectric Power Corporation, was implemented as the respondent number 5. However, although the name of the council is duly shown in the cause list, none has cause list, but none has appeared on behalf of the respondent number 5. Be that as it may, the issue therefore involved herein is as to whether this court can issue a direction upon NHPC, the respondent number 5, that the petitioner's service be regularized and the petitioners be permanently absorbed by the NHPC, by the respondent number 5 to its services. The issue so raised, the issue so raised in the instant proceedings have been already, no, the issue so raised in the instant proceeding touches on the jurisdiction of the court to issue a direction upon the respondent number 5 for regularization of the services of the petitioner, thereby to permanently absorb the petitioners to the affairs in the affairs of the respondent number 5. This court also finds it relevant to take note of even after it has been brought to the attention of this court on the earlier occasion that NHPC, that the respondent number 5 had taken over the project, there has been no amendment made to the writ petition seeking a direction upon the respondent number 5 bitter as it may. The question as regards the issuance of a direction for regularization stands concluded by the judgment of the Supreme Court in the case of the state of
Jammu Kashmir.
huh? No,
State
no,
of Jammu Kashmir.
no. Uma Devi is
Uma Devi versus State of Karnataka.
no.
State of
Uma Devi is
secondary State of Karnataka versus Uma Devi.
by the judgment of the Constitution Bench of this court in the case of the Supreme Court in the case of the Secretary of the EIOPA versus Uma Devi, reported in 2006 for SCC 1, wherein State of Karnataka versus Uma Devi, wherein two issues were arose for consideration before the Constitution Bench. That is, the right of the employee seeking regularization on the strength of long and continuous work, and number 2, the correctness of the directions issued by the courts for regularization of employees under Article 2 to 6 of the Constitution. The Constitution Bench of the Supreme Court in the said judgment in the case of Uma Devi decided both the issues against the employees, holding inter alia that there is no right of the employees seeking regularization on the strength of long and continuous work, and further holding that it is beyond the jurisdiction of the High Court to issue directions for regularization of employees under Article 6 of the Constitution. This aspect of the matter has also been taken note of by the subsequent judgment of the Supreme Court in the case of State of J&K and others report versus the District Bar Association Bandipara, reported in 2017 3 SCC 410, wherein at paragraph number 10, wherein at paragraph number 10 and 11, the Supreme Court dealt with the above aspects of the matter. It is, however, relevant to take note of that the Supreme Court in the case of the state of J&K, in the case of the District Bar Association, Bandipara, had also observed that the judgment of the Supreme Court in the case of the judgment of the Constitution Bench of the Supreme Court in the case of Uma Devi Supra was not an authority for the proposition that the executive or the legislature cannot frame a scheme for regularization. Full stop. Paragraph number 10 and 11 of the said judgment being relevant of the judgment in the case of District Bar Association Bandipara being relevant is reproduced here in under. Next. It is further relevant to take note of that although the Supreme Court in the case of the state of the District Bar Association Bandipara had observed that the judgment in the case of Uma Devi Supra was not an authority for the proposition that the executive or the legislature cannot frame a scheme for regularization, comma. The Supreme Court in the said judgment in the case of the District Bar Association Bandipara had further observed that though the state and its instrumentalities can consider framing up of a scheme for regularization, but the formulation of such a scheme cannot accord a status of an enforceable right. And as such, a writ cannot be issued commanding the state to frame a scheme for regularization. In that regard, this court finds it relevant to take note of paragraph number 26 of the state judgment in the case of state of the District Bar Association Bandipara Supra, which is reproduced here in under. From the above propositions of law, one aspect of the matter to it is above aspects of the matter, above aspects, and above enunciation of law, but laid down by the Supreme Court. It is clear that this court cannot issue a direction for regularization of the services of the petitioner. Cannot issue a direction to the respondent authorities for regularization of the services of the petitioner. It is also clear that this court further cannot issue a direction upon the respondent authorities to frame a scheme for regularization of its employees. Therefore, the relief which has been sought for in the writ petition cannot be granted by this court. Mr. S. Botago, the learned counsel appearing on behalf of the petitioner, however, submits that taking into account that the petitioners have been rendering service since their date of appointment, a legitimate expectation have accrued upon the petitioner for the purpose of their case be considered for being permanently absorbed in the services of the respondent number 5. This court, having given the anxious consideration to the matter, is also of the opinion that taking into account that the petitioner have rendered long services, have been rendering and continues to render services in the Tipamuk project, which has been presently taken over by the respondent number 5. And that the petitioner have been respondent number 5. A legitimate expectation, though the petitioners herein have a legitimate expectation that they would be considered by the respondent authorities to be permanently absorbed in the services of the respondent number 5. This court therefore grants the liberty to the petitioners to submit a representation before the chairman and managing director of the respondent number 5. Who shall, upon such representation, and upon such representation be so submitted, this court requests the respondent number 5, that the chairman and managing director of the respondent number 5 to take a compassionate view of the to the representation so submitted and pass appropriate orders as deemed proper in the exigency of the services of the respondent number 5 with the above the petitions.
Possibly on at least grant some fixed time for consideration of that.
It is however made clear, it is further made clear that Mr. Bottakur, the learned counsel appearing on behalf of the petitioner, submits they would be filing their representation within 30 days from today. So it is observed that if the representation is submitted within 30 days from today, the respondent authorities, respondent number 5, shall do the needful within a period of 6 months therefore. My hands are tied, Mr. Bottakur.
I
Item number 4.
Briefly.
Yes, what is the matter?
Lordship, this matter pertains to selection and appointment of a constable in Central Reserve Police Force.
Then, what remains?
And Lordship, that on 2011, that advertisement was published.
Ah,
He participated in the recruitment proceedings and in the 2011, 2009.
then,
And participated in the recruitment proceeding, and the recruitment proceeding, there are the 4 stages. First one is the physical test, written test, and the medical test. Petitioner qualified the physical test and the written test. Thereafter, he was asked to appear in the medical test. Initially, in the medical test, his candidature was rejected. He preferred on the review. There is a provision for the review. In the review, medical board found him fit. So my case is, Lordship, that there is a provision if a person is fit in the review medical examination, his case shall be considered against the normal wastage vacancy.
against
Against the normal wastage vacancy, Lordship.
wastage.
Normal wastage vacancy. That said, it is reflected in the office memorandum, Lordship. It starts from page 23. And the relevant portion is page 24.
What order did you get then?
Lordship, that if his case is considered against the normal wastage vacancies, then
But can this court direct now?
Lordship,
This happened in 2009.
yes, Lordship, even on the 2017, Lordship.
That's even 6 years from now.
Yes, Lordship.
Then-
That order has been passed. That order has been passed on 2017, Lordship.
Very well.
16.
Then. But how can you now be considered at this age? What is this normal resting vacancy?
Lordship, it
You
is
mean
reflected
page
in the
23?
page 23, office memorandum is start from page 23.
Huh?
And that 24 is an irrelevant.
Sector will cater for vacancies of temporary unfit candidates till such time they are finally declared fit. It is further clarified that even he is subsequently declared fit after appeal to the DIG and conduct of review, then he has to be recruited against
against the
normal.
normal Western vacancy.
So you were otherwise selected.
No, Lordship, otherwise, I have qualified in the first stage of the recruitment process.
Then
That is my thing. And respondent has,
sector will cater for vacancies of temporary unfit candidates
yes,
till such time they are finally
Declared
declared
fit.
fit unfit in the medical. It is further clarified that if an unfit candidate is subsequently declared after appeal to the and the conduct of it. Now this stage, when do you go? Finally come to N. After the conduct of merit, those employees declared temporary unfit will continue to be at the same position in the
in the
merit
merit
list.
list.
However, it will be mentioned that their candidature is provincial. Now you were in the merit list.
Lordship, I have, as per the affidavit, I have secured the 40 marks. And the last selected candidate, as per your affidavit, Lordship, he has secured the 43 marks.
But then nothing remains.
Yeah.
How do you bring this?
Lordship, last selected candidate secured 43 and he secured 40. Therefore, he was not in the merit list.
So you don't come within
Yes.
that thing. A person who is otherwise selected
Otherwise,
everywhere
Lordship,
and has been declared unfit,
he was in
later on
merit-
become fit,
in the
then
merit
he
list.
may come.
Yes.
You
And
don't come.
yes, Lordship.
What do you mean?
And also in the, he has claimed Lordship paid for Western vacancy, but there is no Western vacancy. Lordship.
Madam,
All the posts have been filled
madam,
up.
You have already finished him with that 43. How
43, okay.
much do you want to destroy him?
Lordship,
Lordship.
that- no,
It is
Lordship,
infructuous, Lordship.
Huh?
It is infructuous. Because
Infructuous.
infructuous.
Lordship, the one is.
It's infructuous.
Total,
If it is infructuous, it becomes easier for me.
Lordship.
Lordship, the total 543 posts were advertised. If someone has not joined in that post, so there is some vacancy. Against those vacancy, my candidacy.
There is no vacancy.
Did you submit a representation thereafter?
Lordship, not. I have not.
Why
checked it.
should this court do all this business out there? Huh?
Yes, Lordship.
Okay. Now, the case of the petition, the instant writ petition has been filed by the petitioner, seeking a direction to the respondents to appoint the petitioner as CT/GD in the normal wastage vacancy in accordance with the circular dated 15/7/2005 and 8/9/2005. The case of the petitioner is that the petitioner, pursuant to an advertisement number 1 of the year 2009, for filling up of vacancies of the rank of Constable General Duty in the Central Reserve Police Force, submitted his application full stop. The petitioner was allotted a roll number 09513280009844. Full stop. It is the case of the petitioner that the petitioner appeared before the recruitment board and participated in the physical standard test and the physical efficiency test and successfully qualified the same. Thereupon, he was called to participate in the written test. The petitioner also claims that he had successfully passed the written test and secured his position in the merit list prepared by the respondent subsequent to the written stage. Subsequent thereto, the petitioner was also called for the medical test to be held on 12/1/2010 at the Group Center CRPR, Amarigog, Guwahati. The petitioner appeared on 12/1/2010 in the medical test. However, he was declared to be unfit due to defective vision, varicose vein, cubitus vulgus, and bow legs. The petitioner thereupon preferred an appeal against the rejection on medical grounds. And on appeal, it was decided in his favor, in favor of the petitioner, that the petitioner was not medically unfit. It is under such circumstances that the petitioner therefore has approached this court claiming that he should be accommodated against the wasted vacancy in terms with the circular dated 15/7/2005 and 8/7/2005 of the respondent of the Directorate General CRPF. The petitioner thereupon being aggrieved by the respondent authorities not giving him the appointment in terms with the said circulars against the wastage vacancy, had filed the writ petition on 5th of September 2011. It reveals from the records that this court had issued notice on 19/9/2011. The records further reveal that the respondent numbers 1 to 4 had filed their affidavit in opposition. In the said affidavit in opposition, it has been mentioned that the petitioner was a general category candidate. And in the merit list, the last selected general category candidate obtained 43 marks, whereas the petitioner obtained only 40 marks. And as such, the circulars referred to by the petitioner, thereby claiming a direction for being appointed in the wastage vacancy would not apply. Upon hearing the learned, this court, upon perusal of the materials on record and upon hearing the learned counsels for the parties, this court have perused the materials on record. The learned counsels for the parties have been duly heard. This court have also taken note of. There is no dispute that the petitioner had obtained 40 marks, and the last of the general category candidate had obtained 43 marks. In the backdrop of the above, let this court therefore take note of the circular dated 15/7/2005. From a perusal of the circular, the benefit under clause O would only be available provided the person concerned, provided the candidate is selected in the merit list. In the instant case, as the petitioner had obtained marks below the last selected general category candidate, that is 40 marks against the last of the candidates obtaining 43 marks. This court is of the opinion that a circular dated 15/7/2005 as well as the circular dated 8/9/2005 would not aid in the cause of the petitioner. Accordingly, this court finds no merit in the instant writ petition, for which the writ petition stands dismissed.
Much obliged.
Item 5.
Who is appearing for the central government? One Pujot Matipa. Calculate this.
Item 6.
May please your lordship. And this is an application against an award, my lord.
You're challenging an award.
Award.
Why?
My lord, award is my lord. My lord, award is on the face of it bad, my lord.
Hmm?
Because the award is bad, my lord, because domestic inquiry was held by the inquiry officer. And in domestic inquiry, my lord, I will take your lordship to that, my lord. Domestic inquiry report is that, my lord. There is no basis of the finding, my lord. I will take your lordship to that, my lord. Domestic inquiry. In domestic inquiry, my lord, if your lordship permits me. Before that, I will take your lordship to the award. Domestic inquiry are held by the courts, my lord. That is the validity of the domestic inquiry, but that was rejected and ordered.
So it is on the fairness of the domestic inquiry.
Yes. Because on the basis of the domestic inquiry.
Let's see your written statement. Where did you say anything about the written statement about the domestic inquiry?
At page 20, my lord. There, paragraph 8. Not being satisfied of the workman's defect, the management instituted a domestic inquiry conducted by the landed advocate. The inquiry inquiry, it may be submitted in all fairness suffered from various lacunae, which nakedly violates the canon of natural justice, equity, and fair play, inasmuch as the management in all its wisdom, while ignoring such lapses, concurring with the report of the inquiry officer mechanically and without giving any serious thought, have taken the extreme step of dismissal of the workman with effect from 1 a clear outcome of a deep-rooted conspiracy held by the management against the poor workmen for their selfishness. To cite one instance for such a lapse, while issuing the notice for the inquiry to the workmen, it has failed to enclose the list of witnesses for the management to be examined at the inquiry, which is mandatory under the prevailing law, else it will vitiate the inquiry footage. The evidence of the witnesses were not assessed properly and with a judicial mind by the inquiry officer. While arriving at a conclusion finding the delinquent one guilty of the charge. Then another factor that has
Well,
struck the Songkong is the peculiar comment of the inquiry officer at page 11. That is very important matter.
Which one?
Page 11, my lord. The inquiry report he says, my lord. From a thorough perusal of the evidence on record, I'm going to the domestic inquiry report. It says, from a thorough perusal of the evidence on record and of the documents produced, I have reason to believe that the entire shell matter is wrapped in a shroud of mystery. Can there be any unholy alliance among the three, namely the delinquent workman Podon Gogoi, the then assistant manager Ankur Jyoti Sharma, and the then manager Shri S. Das? I am not authorized to take a decision thereon involving them, assistant manager and the manager. This is the observation of. In spite of that, my lord, the punishment of dismissal has been awarded to the workman.
No, what is the fairness? Fairness means it has been done properly. What else? You are, why are you saying that there has been a prejudice to you?
My lord,
There has to be some prejudice to you.
yes, my lord.
What is the prejudice?
At my lord, that paragraph indicates, my lord, his prejudice, my lord. That paragraph, that is there, my lord, he says that the unholy alliance among the three, my lord, the workman, manager, and the assistant manager, my, that is 1 point. My lord. And in spite of that, my lord, the award has been passed, my lord. Again, I will take your lordship, if your lordship permits me.
No, kindly come to this one, paragraph number 8 at page 20 of your written statement. Here you have alleged that the list of witness was not given to you.
On this, my lord, I will not argue today, because my main submission before lordship.
Madam, you have to finish the argument today only.
Unless I will not, my lord, I will not insist on that. My main argument before lordship is that the report is bad, my lord, and on the basis of report, my lord, the punishment has been given to the work
So you are saying on perversity of the report.
on purpose.
Let's see then what is the perversity on the report?
Before domestic inquiry, my lord.
Hmm.
The manager was not examined, my lord. Assistant manager was examined.
Report,
Yes.
exhibit 2. You are saying about the perversity of the domestic inquiry report.
Yes.
Let's see, what is the perversity of here?
I will take your lordship to the report itself, my lord.
Yes, I'm looking into it, exhibit 2.
Yes. This report is prepared at the conclusion of the inquiry in respect of this search.
Paragraph,
This is paragraph 1 from the beginning.
are you saying about the domestic inquiry report is that exhibit 2? Paragraph number 1 says, the number 2 is the case for the management
Yes.
in brief.
Yes.
Okay.
Rana Borua joined the post of manager in the Borjan Tea Estate on 1st April 2007. After he had joined, he received an information from the head office that some serious irregularities had occurred in the sale of caps of Borjan Tea Estate. He was advised to hold an inquiry. Accordingly, he called the store clerk of the tea estate, Poton Gogoi, who told him during course of interrogation that some caps were sold on 21/2/2007 by the then manager and assistant manager. The manager then called the purchaser of the scap, the Dasarath Shah, who admitted to have purchased the scap for rupees 75,000. And Dasarath further told that he deposited the said amount at the office of the garden. On query, the head clerk of the office of the garden told after consulting the relevant record that the record did not show deposit of 75,000. The manager recorded the statement of Poton Gogoi, store clerk, and purchaser Dasarath Shah. On being not satisfied with the explanation of Sri Poton Gogoi, the manager reported the matter to the deputy general manager of the estate.
And what is the name of the delinquent employee out here?
He is Poton Gogoi.
Bodon Gogoi,
Poton
head clerk.
head clerk.
Okay, then
He is not head clerk, my lord.
Store clerk.
He is store clerk.
on being not satisfied with the explanation of Bodon Gogoi, the manager reported the matter to the deputy general manager of the district.
Who thereupon requested the account finance of Tata Tea Company to make an inquiry. The accountant Santanu Chatterjee conducted thorough inquiry and found from the statement of Poton Gogoi and Dasarath Shah that an amount of rupees 75,000 was received by Poton Gogoi against the sales cap of 21/2/07. The accounts further found that from the record of scap sale registered that on the amount of 1932 was deposited in the office of the garden. The accountant made further inquiry into the sales cap during the entire period of 2006. It was found as full. But for this, my lord, no notice was given to me.
Which one?
This subsequent matter, subsequent period.
This is an internal inquiry before
Yeah,
initiation of a year.
Ex-
Yeah, then
On receipt of the report of the company's accountant, the manager issued charge sheet to Sri Poton Gogoi, alleging that Sri Poton Gogoi collected rupees 75,000 from Dasarath Shah as purchase of sale on 21/2/07, but deposited only 1,932. It is further alleged in the charge sheet that duplicate copy of the gate pass bore the signature of Poton Gogoi on it, and this indicated thereby that Sri Poton Gogoi has been sending out company's property from the factory premises under his signature without knowledge of the management. It was also alleged in the charge sheet that Sri Poton Gogoi had not even keeping any record of actual quantity of cash sold or details of the party who had purchased the shares. No letter of sale was given to any party. According to the management, the above act and conduct of the workman Poton Gogoi so that Poton Gogoi has tried to hide facts of sale of company's property which nullify the intention, and this amounts to gross misconduct on part of Sri Poton Gogoi. The presenting officer of the management has placed the charge sheet before me. It is read upon and explained both in English and Assamese to the delinquent workman Poton Gogoi who please not give. The management has adduced evidence of 5 witnesses who have duly cross-examined by Sri Poton Gogoi. The workman Poton Gogoi has given his own statement in writing, has adduced no other evidence. Now the points that fall into consideration in this inquiry are whether there are sale of scap of Borjan Tea Estate on 21/2/07 and the sale faced in the amount of rupees 75,000. Whether Poton Gogoi received the sale proceeds of rupees 75,000 from the purchaser. Whether Sri Poton Gogoi deposited 1932 out of 75,000. Whether balance amount was left unaccounted and it was lost to the garden property. And the others are my lord regarding other amounts. Therefore, I will take your lordship. On the management side, the evidence of the Ankurjyoti Sharma and Santanu Chatterjee are important. Ankurjyoti Sharma is stated to have been in overall charge of the store of the garden. Santanu Chatterjee conducted an investigation relating to sale purchase of scap only on 21/2/07 and during the year 2006. From the evidence of Ankurjyoti Sharma, it is seen that there is no categorical statement that the Poton Gogoi handed over an amount of 75,000 towards the sale purchase of scap sale on 21/2/07. But during the course of cross-examination of the witnesses, Poton Gogoi suggested to the witnesses that he, Ankurjyoti Sharma, knew that the amount given to manager by Poton Gogoi was 75,000. Sri Shantanu Chatterjee has stated that he recorded a statement of Dr. Shah, Madan Gogoi and Ankurjyoti Sharma, which are marked as Exhibit 12, 13 and 14. These exhibits are important that I will take your lordship to there. This statement show is sale of scarce for rupees 75,000. I have perused the statements of Dr. Shah, Madan Gogoi and Ankurjyoti Sharma. Even though Ankurjyoti has stated that he did not count the amount. The purchaser Dr. Shah and delinquent workman Madan Gogoi has stated that the sale purchase of scrap sale on 21/2/07 was rupees 75,000. These statements recorded by Shantanu Chatterjee are not disputed by the delinquent workman Madan Gogoi. In my view, these statements can be accepted for consideration. On defense side, the statement given in writing before me by Madan Gogoi does not mention the amount of sale purchase of scrap sale on 21/2/07. At the same time, he has not denied that the amount of sale proceeds was 75,000. In the course of statement, he merely tried to shift the liability to his senior officer. Regarding the fact of sale on 21/2/07, nothing has been stated by the delinquent workman. The allegation of sale of scraps on 21/2/07 has not been denied. He merely stated that he himself did not sell the scraps. On the other hand, this statement given by Dr. Shah, Madan Gogoi and Ankurjyoti Sharma simply show that the scraps of the tea estate were sold on 21/2/07. In the light of the discussion above, I am of the opinion that the management has been able to prove first point, and hence this point is decided in the affirmative. I now come to the second point. It is whether Madan Gogoi received sale proceeds of 75,000 from the purchaser of the scraps. Here too, Ankurjyoti Sharma has stated that 21/2/07, Madan Gogoi placed a packet on the table of manager, saying that that was the scrap sale money. In the statement of Dr. Shah and Madan Gogoi, even during the course of investigation by Shantanu Chatterjee, there is mention of the fact that the Madan Gogoi received the sale proceeds of rupees 75,000 from Dr. Shah. I have already mentioned that these statements are not disputed by Madan Gogoi. Shantanu Chatterjee has duly identified the signature of Dr. Shah and Madan Gogoi. In the statement given in writing, the Madan Gogoi has nowhere disputed the fact that he received the amount of sale proceeds. In his reply to so-called notice, marked at Exhibit 25, Madan Gogoi has stated that he had only counted the amount of 75,000 given by Dr. Shah. All these facts discussed above lead to the conclusion that Madan Gogoi received 75,000, being the sale proceeds of scrap sale on 21/2/07. The second point is therefore decided in the affirmative. And workman Mala never challenged this matter. He accepted that he received the amount. For convenient discussion and consideration, I now taken up third and fourth point. Third point is whether Madan Gogoi deposited 1952 out of 75,000. Fourth point is whether balance amount was left unaccounted and it caused loss to the guardian property. It is seen from the evidence of Dhaneshwar Kumai. He is a clerk minor who is in charge of the cash section of the state. According to him, on 21/2/07, Madan Gogoi deposited 1932 to him, along with a sales statement signed by then manager and assistant manager. The sales statement, details of scrap sold were recorded. The witnesses had produced the scrap sale register and shown the sales statement, which is marked as Exhibit 1. He entered the amount in cash book, which is marked as 2/1. This part of evidence is not disputed by the delinquent workman Madan Gogoi. Sri Ankurjyoti Sharma, PWT, who too participated in the transaction in his capacity as factory and store in charge, has stated that the sale proceeds recorded in the sales statement were directly disbursed to the head clerk by Madan Gogoi. The statement of the Madan Gogoi recorded by Shantanu Chatterjee also shows that he received the amount 1932 from the assistant manager Ankurjyoti Sharma. The statement given in writing in the course of inquiry, the workmanship Madan Gogoi has not specifically denied the fact of receipt of the amount of 1932. He merely tries to justify his act by shifting responsibility to his senior officers. In the light of the discussion made above, I am opinion that management has been able to prove that the Shantanu Chatterjee's report, Exhibit 15, clearly shows that the state has sold scraps of 75,000 on 21/2/07, but relevant official book and records do not reflect the entire realization. The state had on the particular date accounted for 1932 only. The report is not challenged by the delinquent work. The necessary conclusion is that there is a loss of guardian property to the tune of 73068. The third and fourth point are therefore decided in the affirmative. Paragraph 9. Here also the evidence of the head clerk has produced sale account statement of this is another period. I will take your lordship to paragraph 10. I am now taking up 6, 7, and 8 points together for convenient discussion. Regarding 6 points, whether Sri Bodon Gogoi has been sending out company's property from the factory premises under his signature without the knowledge of the manager. The proof fact is that number of scrap items shown in the sale statement kept in the custody of the office. So which are the carbon copy of the original gate process already issued. As a storekeeper, it was the duty of the storekeeper to maintain record of annual sale of scrap and the name and purchaser daily counters and by the factory and store. Necessarily, therefore, it follows that Sri Bodon Gogoi has not been keeping record of actual quantity of scrap sold and detail the purchase we had purchased. Therefore, my lord, from a thorough perusal of the evidence on record and of documents produced, I have reason to believe that entire sale matter is wrapped in a shroud of mystery. Can there be an unholy alliance among the three delinquent workmen, Bodon Gogoi, the then assistant manager, Sri Ankur Sharma, and then manager, Sri Rita? I am not authorized to take a decision thereon involving them, then assistant manager, and the then manager. I am to see whether the entire sale of scrap there are dishonesty on the part of Bodon Gogoi. The admitted position is that carbon copy of gate pass were kept by the store clerk for his conflict. The evidence of Ankurjit Sharma is that in many gate passes it did not his signature. In such situation, gate passes were signed by the store clerk and guardian properties were sent out on the strength of those gate passes signed by the store clerk. He did not sign the original gate passes. According to Ankurjit Sharma, whenever a scrap was required to be sent out of the guardian, the store clerk simply produced the original gate pass for signature. It appears to be beyond office procedure. No explanation is forthcoming from Ankurjit Sharma as to why he did not insist for production of the whole gate pass. I am told in the course of inquiry that original gate pass are destroyed in the very next state of space of those scraps. There is no scope to verify the statement of the sole item. The carbon copy of the gate pass with the items mentioned in the original gate pass.
So your case is there is an involvement of 3 persons which have been found by the inquiry officer. And why you have been only made to skip? Yes, what have you done with the other 2?
My lord, the entire facts has been taken account into by the labor court. And when the labor court, my lord, have taken the entire facts, my lord. If lordship, I can show from here that the discussion made in page 31 of the labor court award, my lord. So their domestic inquiry claim, my lord, regarding prejudice is already taken care of labor court. Now under 226 interference, they have to show any other ground of perversity. May I read page 31, my lord? And the entire, my lord, issue is of misconduct of theft, my lord. Serious offense, my lord. That is the thing, and that was continuing from 2006. earlier also in the search sheet was reflected. In 2006 also he was continuously doing it. And last.
Let's see how the labor code took into
Yes, my
account the fairness of the inquiry.
Page 31, my lord. If I can read from MW1,
Hmm.
page 31, middle portion, according to management witness 1, Prasad Kumar Thakur, enquiry officer, on being appointed by management, he conducted domestic enquiry against the workmen from 22/9/2007 to 2012/2007 in presence of 2 independent observers and the workmen. He said that on being read over and explained, the workman pleaded not guilty to the charge. He claims that he examined 5 management witnesses during the inquiry and they were cross-examined by the workman. He avers that thereafter the workman declined to examine any witness in support of his case and submitted only a written statement. He says that thereafter, hearing both the sides, he prepared Exhibit 2 inquiry report and submitted the same to the management. MW2 avers that he was present at the inquiry as a neutral observer. He claims that next page in the inquiry, the workman was given all the opportunities in deciding, including the opportunity to cross-examine all the material witnesses. He proves Exhibit 1 to as his signature as neutral observer in Exhibit 1 proceeding of inquiry. MW3, Dhaneshwar Gohai, head clerk of Borzan Tea Estate, claimed that he deposed for the management in the inquiry and the workmen cross-examined him. He avers that the inquiry was conducted following all the relevant procedure and the workman was given all the opportunities therein. He proves Exhibit 1-3 as his deposition in Exhibit 1 proceeding of inquiry. MW7 Rana Borua, the then manager of Borzan Tea Estate, inter alia says that after making a preliminary inquiry, he issued Exhibit 3 search sheet to the workman. And on finding Exhibit 12 reply of the workman thereto not satisfactory, he initiated a domestic inquiry against him, which was conducted by Prasad Kumar Thakur. He avers that after the inquiry officer completed the inquiry holding the workman guilty, he issued Exhibit 13, second show cause notice. This is important, man. Second show cause notice to the workman, but the workman did not submit any reply thereto. And so on 7/3/2008, he dismissed the workman from his service by virtue of Exhibit 14 dismissal letter. Now your lordship will come below, my lord, page 32 below. In his WS, the Songo, that is for the workman, claimed that the workman was not given the list of management witnesses at the time of issuing notice of inquiry and on being examined as WW1, the workman himself support that plea made in the WS, thus that made the inquiry invalid. It cannot be disputed that the provision which requires furnishing of list of witnesses and other documents to a delinquent employee of a domestic inquiry are procedural provisions. In Omrit Devan so-and-so, His Lordship Honorable Justice so-and-so of our High Court held that procedural provisions are generally meant for affording a reasonable and adequate opportunity.
And these are okay.
Yes.
Prejudice is to be proved.
Then page 34, my lord.
Thus from the above,
Thus, from the above mentioned decision, it becomes clear that non-furnishing of the list of management witnesses to a delinquent employee of a domestic inquiry constitutes only a procedural lapse, and it does not vitiate the domestic inquiry unless the delinquent employee pleads and proves that it has caused prejudice to him, resulting in miscarriage of justice. The said decision also clearly showed that such prejudice must be proved and not presumed. When in the light of the above principle of law, we turn to the evidence on record to see whether the workman has been able to discharge the burden of pleading and proving prejudice in this case, it is seen that neither in the WS nor in his evidence has the workman made any claim suggesting that he suffers prejudice because of the said procedural lapse, resulting in miscarriage of justice. On the other hand, cross-examination of MW1 reveals that the workman did not make any complaint before him regarding his not receiving list of witnesses. This is also
Mr. Borua, at this stage, let's come to paragraph number 8 of the written statement,
paragraph 8 of Songo, my lord.
page 20. Come to the last 5 lines from the bottom.
Yes,
To cite one witness instance.
yes. To cite one instance, may I read it, my lord?
Yes,
To cite one instance for such a lapse while issuing the notice for the inquiry to the workman, it has failed to enclose a list of witnesses for the management to be examined at the inquiry, which is mandatory under the prevailing law. Else it would vitiate the inquiry proceeding. The evidence of the witnesses were not assessed properly and with a judicial
this is
mind.
okay, no problem with
This
it.
is their
Yeah,
WS.
so here he says that the list of witness not being done.
Yes.
It goes against the proposition of law,
Yes,
not as regards what prejudice has been caused.
that
Okay.
is,
Now let's come back to again. This page 34.
yes, page 34.
In view of the above, I find and hold that the workman had failed to discharge his burden of pleading and proving prejudice because of the concerned procedural lapse. Cannot be held to be invalid. Now kindly come. Another claim made by the Sangha in his evidence is that the inquiry did not allow the workman to examine the former garden manager and production of the original records like gate pass were not allowed by him and the purchaser of the scrap materials as well as gate paper were also not examined. Was this Dasarath saw not examined? Their statements were recorded.
Yes, recorded. Your statements are recorded.
However, in his evidence as MW and the workman himself only claims that the management did not examine the manager as a witness during the inquiry and that the gatekeeper was also not examined in the inquiry as a management. The crossing on the remand. So, it is the third- there is not a single in the evidence. Now, whether the workman during that inquiry asked that he wanted to adduce evidence of these two persons.
My lord, Dr. Shah, this cab leader was examined, my lord, as MW4. MW4, my lord. And another, my lord, one statement, exhibit 12, management has next one, exhibit 12. So, also promised me I will take a lot of do that. That is statement of Dr. Shah. He said, Dr. Shah came to the go down clerk M.B. Gogoi on 21/2/2007 at around 8 a.m.
No, madam, I'm only asking. Did you ask during the inquiry proceedings that I want to examine the earlier manager? If you have not done that, you should have asked and then only the if that is not being given. But if you have not asked for, how do you take care of that situation? I would have understood if you have asked, he would have not permitted, and this would have made a substantial difference. The question would have been different. But if you have not asked, how can you hold that the inquiry is bad for that purpose?
And the labor code itself reflected that portion, lordship query.
Because if you see the amount which was taken, there is a clear finding to the effect that 75 lakhs was 1,000 was received, and of which the amount was not only 1932 was deposited. That's a finding of fact.
But the evidence is that, my lord, amount was given in presence of manager and assistant manager.
Understood, but why haven't you asked them for bringing that manager and assistant manager? They say that yes, these people are there, they are also involved. But the fact that
assistant
the
manager-
inquiry officer did not, but you were also one of the persons who were involved. Whether they have done anything against the manager or the assistant manager, this is another aspect. But the fact that you were also involved or there was a conspiracy between you, the assistant manager and the manager is already there. That is the finding.
of the-
And it,
Right.
on the basis of that finding, the question comes as regards if it is a case of misappropriation, well, wouldn't it be a case of loss of confidence?
Yes.
And if it is a case of loss of confidence, where is the question of reinstatement?
If you also promise me, I will statement of Dr. Shah, that is there in the annexure 6. If you also promise me, I will take the also to that.
Annexure 6,
Statement of Dr. Shah, exhibit 12. Annexure
page,
6. Uh,
you are saying, referring to which one?
from my document matter,
Or in the inquiry?
it's inquiry matter, domestic inquiry.
Exhibit 6.
6/12/07. Exhibit 12 or annexure.
Yes, statement of the Suraksa.
Yes.
Yes, I've seen.
I, Dasarat Shah, came to the godown clerk, P. Gogoi, on 21/2/07 at around 8 a.m. in the morning to inquire whether there are any scrap materials to be taken. Godown clerk told me that gunny bag and CI part are to be lifted. I saw the materials to be lifted and went off to get the lorry. I returned around 2 p.m. in the afternoon and with the lorry and started loading the cast iron in presence of godown clerk. After loading of the cast iron, I then took the gunny bag, which were both damaged and good quality. The weightment of the lorry was done in presence of godown clerk. As I do not know the estate management, I cannot identify whether any management staff was there or not. Total amount of rupees 75,000 was given to godown clerk and he gave to the management. I took the gate pass and went off with the lorry. And this is supported by evidence, my lord.
And there you have also signed it.
Yes.
That document, you have also signed it. Indeed, this has been done in your presence, isn't it?
Yes. And
Godown clock is you. Yes,
Yes.
Godon Gogoi.
for the
Then now you see in your statement at exhibit 13, exhibit 10, you have stated that after entire loading was over, I prepared the worksheet item wise, rate and so, and showed the same to the factory assistant manager. The total amount was rupees 75,000. The assistant manager asked me, where is the amount? I went to the party, received the amount from the trader and came to the manager room. I handed over the amount of rupees 75,000 after counting to the amount, counting to the factory assistant manager in front of the manager. He counted the money and found the to be Okay. Factory engineer signed the original copy of the gate pass and handed over to me. Taking the gate pass, I went out to the manager's room and handed over the gate pass to the trader. The party went off with the truck. I was standing outside the room. Factory came and gave me rupees 1950 as the sale proceeds to be prepared. Then I asked him that when rupees 75 is the realization, why so and so. The factory replied that the manager had asked to prepare the documents based on this only. I asked that how will he prepare the statement? He replied that it was instructed by the manager as per the statement so and so. Iman, all this was told by the assistant manager. As per his instruction, the duplicate copy of the year was here of the gift.
Evidence is that my lord, he received 75,000. He deposited it before the authority construction.
Show your reply. Where's your reply? Where do I get your reply?
Page 13, my lord.
Hmm?
Page 13,
Page.
13.
And exhibit is what?
Annexure to in my petition.
It is not here in the main file.
Must be there.
Repeat. Reply to the show cause.
Reference to the focus notice 3870, my written explanation is given below. I have objection on the style of construction of paragraph in point number 1. Actually, this same has to be as follows. As part and assistant manager of the factory, Mr. A.J. Thomas instruction, I had only counted the amount of rupees 75,000 given by the Dosarath, and in front of the Dosarath, I returned the money to Mr. A.J. Thomas. I had told the same before the company's accountant in front of your honor, head clerk. Mr. A.J. Sharma also agreed with my same person and accepted my information given to the company's accountant that he had given me rupees 1932 out of the rupees 75,000.
No, therefore your case is Dasarath Shah gave you 75,000. You gave it to the manager
And assistant
and the assistant manager, the factory manager.
manager.
The factory manager only gave you back 1932 and the remaining amount was not given to you.
And I was given the gate pass and I came out with their pass. And what happens thereafter, I do not know. That is my.
Mr. Borua, did you corroborate this story anywhere?
My lord, in our management WS, we have stated nothing.
Where?
Page 19, my lord. Para 6
Page 19 is there.
in the writ petition. Oh, my lord, I'm sorry.
No, written statement of
Page-
the management, page
Page
23.
23, my lord.
Yes, tell me.
Paragraph 3, my lord. 3 onward, that the workman, Sri Bodan Gogoi, was store clerk of Borjan Tea Estate on 21/2/2007. He had
That I
collected.
have seen it. He has deposited 1932. He is also not denying that. I have
Yeah.
only deposited 1932. But his specific case is, they look here, I take the money from Dasarath Shah. That was the 75,000. I gave it to the manager. The manager gave it to the so and so and gave him 1932.
Yes.
So under such, did you say corroborate that incident? Because here is a case of, one thing, in the tea gardens, you can't do anything.
Yes.
Higher officials out there, they do something, you can't help it on it. Now, is it the requirement that the money which is being received by the godown clerk or the store clerk has to be deposited to the cashier and not to the manager? Show me that.
Yes.
Because here he says, yes, I received the 75,000. I gave it to the so and so, and that has not been done. Now, if you have not corroborated and have only on the basis thereof have only inflicted the punishment upon him, not upon others, then would it be fair? He couldn't do anything.
He was with the.
Understood. And that is also the inquiry report.
Report.
The inquiry report also says that both three of them must have been involved.
And that is the then assistant manager. He retired.
Understood. But then also you have not inquired.
Now my lord, so far his involvement is there, my lord. That is, he has not failed to conclusively prove his case. That he.
His
has to prove-
only thing is why you have not informed the higher authority. Yes, one thing is that he was given 1932.
Yeah.
He should have informed to the higher authority.
Yeah.
And that higher authority being not informed, you have blamed him. That is could be seen from the award also, as well as the inquiry report, isn't it?
No, one thing is that, my lord, in our written statement, the manager who joined, my lord,
Hmm.
that is para 4 in our page 23.
Hmm.
He, my lord, found serious irregularity.
Understood. Then there is no quarrel with the fact that
Yes.
75,000 was taken, that amount was not deposited.
Yes,
It is an irregular. There is no quarrel. He is also not denying
yes. He's not-
that the amount has been received that was not deposited. This is not his case. He said that I gave it to the manager didn't give it to me. He only gave me 1932, which I have deposited. That is his specific case. And the inquiry report also serves that yes, these are the three persons who are involved.
my lord, some cloud there, he's casting a cloud that perhaps these two persons, but
No, not only he, the inquiry officer's report also says so.
the inquiry report say he was not directed to inquire against the other two persons except.
No, he further says in his inquiry report, categorically he says that.
Is,
In his inquiry report, he says, you see, internal page 11. From a thorough perusal of the evidence on record and of the documents produced, I have reasons to believe that the entire sale matter is wrapped in a shroud of mystery. Can there be an unholy alliance among the three? That is the delinquent, the then assistant manager, and the then manager. I am not authorized to take a decision thereon involving so and so. Now, the fact that thereupon what has happened is he had not reported to the higher authorities. And that is the reason why you have implicated that he is only the person involved. But have you inquired with the earlier managers? No.
the present manager has deposed, my lord.
Yeah.
Present manager, my lord.
Was any question being put
Yes,
during the
yes.
cross-examination,
The
madam?
Labor court judgment, if you also see,
That whether there was an inquiry being made by the management from the earlier manager?
yes, ma'am. PW7, MW7, page 32.
Of?
Of the award, madam. Page 32 of the writ petition award. May I read it? MW7, Rana Borua, the then manager.
The then manager was there?
Yes,
Where?
my lord, in the award, page 32 of the writ petition.
Of the award.
Yes,
Yes. He's the MW7 was the then manager.
yes, my lord.
Who was
Then
involved?
manager Borjan T State Interior says that after making a preliminary inquiry, he issued exhibit 3 search sheet to the workman
No, this was not that manager. That manager was Esdas.
as thus.
My question therefore is, did you inquire with the factory manager then in this, taking into account that in the inquiry, it has been categorically mentioned that yes, he may have been involved. Why not the others?
Perhaps, my lord, that for not being a witness, my lord, that they have failed to show that they are prejudiced. That is the case, my lord. In the list of management witness,
Hmm.
They have not plead any prejudice been caused to them. But he is also one of those workmen, my lord. And therefore, my lord,
That it was the workmen from the service.
second so cause notice was issued to the work.
What is your reply to that particular statement in paragraph number so and so? This particular paragraph. In fact, madam, what I am also asking him, it's outside the purview of your writ petition. You have not made a single statement also to that effect. You are saying that this is wrong, illegal, whatever may be. There's not a single statement also.
My lord, I have one judgment, my lord.
What?
Misconduct of theft, my lord. And when the labor code take entire facts, my lord, interference of 226 has to be very, my lord, limited.
Give
And, and when the management lost confidence, my lord, that is another point. Starts from
The loss of confidence is there. The
Yes.
question of reinstatement doesn't arise.
para 12 onward. Para 12 onward, my lord. Okay.
Madam, there is nothing on record to say that you have sought the examine the statement of these two managers during the inquiry. Now, in the labor court, you can also ask these persons, no. As a witness. The court has the power, the labor court has the power to summon.
But that was not.
Then why was not that done?
Not done. Because Because
Obviously, they would say no, that's a different thing, but
it's
they
a
know.
higher authority, my lord.
Hmm?
It's a higher authority, my
No,
lord.
no,
My
once
employer,
they
my
have
lord.
lost, they are no longer in the job, you can very well. No, I'm not saying then in the domestic, in the lower court, why, in labor court, why haven't you taken that?
Considering the nature of case, my lord, our Songpa is confident that they will get back their job, my lord, because there is no lapse on part of the work. That's why, so it will be another.
Hmm. No, I understand the predicament, but the problem is for this court to interfere with having not done that.
So, my lord, the workman is a small fry, my lord. How can he fight with a?
This is I know, this is I have told you.
Yes,
That he happens to be a small fry, but
yes.
if you have not done anything
And my
or
lord,
the procedure is not done,
as because, my lord, the evidence is there, my lord, that he did not take the amount, he deposited the amount. It is clear on the from evidence. And for that, there is no.
no, he has only deposited 1932.
No, my lord.
The fact that
No,
he
yes,
received, no,
yes.
you see, madam, first, the fact that he has received from Darsanath Saw, there's no denial. He had deposited 1932, there's no denial. Now the question is in between
That-
as to whether he has given it to the manager.
But it is, yes, my lord.
That is the question which is, there's nothing.
Cannot prove, my lord. And for the part of the workman, it's very difficult, my lord, to fight against mighty management. But that is the problem. And from facts, my lord, it is clear that, my lord, he deposited the amount before the manager. My
But how do you say so? It is only your version.
lord. No.
It's only your version. There's nothing else which is there.
From the scam dealer also, he made statement.
The
that-
scab bill, you see, you in your own written statement as well as also in your reply categorically admit that yes, I have received this 75 lakhs, 75,000. Thereafter, I went to the manager along with that factory manager. The manager kept this 75,000 and gave me 1932, and that I deposited. Now, from all the evidence which is seen, it is proof that 75,000 has been received. This is an admitted fact by you. The fact that you have deposited 1932 is also by you. The only fact which have nothing on, there's no other evidence out there which you couldn't show is that you gave it to the manager.
As because it is a fight between two unequals, my lord. That is the point.
Understood, but that
Well,
something has to be done. I would have otherwise very well.
May I pray, my lord?
Hmm.
Your lordship may demand back the matter, my lord. For
No. These all matters, no remand back.
I think and the
I'll help
workman
it
is about
this one.
47 years old, my lord. With the time bound, your lordship may demand the matter.
For what? What are you going to do now? Tell me. You had the opportunity there. And you did not avail that. Then how can this court do it?
Because of the situation, my lord.
No, I would have understood, okay, before the inquiry officer, you did not. You should have the word in your written statement also, or in before, or your statement, any statement out there. You even chose not to give evidence in the tribunal,
That is the
in before the inquiry officer. As regards the tribunal, you have given evidence, but nothing could you could have very well asked, because the labor court had the power to qualify any witness. You should have asked that, and if then nothing would, this person wouldn't have come, then this court could have done something. I can't do anything out there. Ricky, ole? Oh, hello. তোৰ টোপনি মাৰাটো ভাল। এইটো নহয়, তোৰ টোপনি মাৰাটো খুব বেয়া। Okay. Look. The instant writ petition has been filed challenging the award dated 27/12/2010, passed by the Learned Labor Court of Assam at Dibrugarh in reference case number 1/2009, whereby the Learned Labor Court upheld the decision decided the reference by upholding the decision of the management of Borjan Tea State of to dismiss the petitioner, to dismiss the delinquent workman the facts involved in the instant case, as would be apparent from the perusal of the writ petition as well as the LCR, was that the petitioner was appointed, was that the delinquent, that one Bordon Gogoi, hereinafter referred to as the delinquent workman, was appointed as the store clerk with effect from 1/4/2001. On 1st of April 2007, one Sri Rana Borua joined the post of the manager of Borjan Tea State. It reveals from the records that after the said manager joined, he received information from the head office that there were some irregularities in respect to the sale of scrap of Borjan Tea State. Accordingly, he held an inquiry. During the course of the inquiry, the delinquent workman, who was also the store clerk, was called, and he was inquired, and upon him various inquiries were made as regards certain sale of scrap on 21/2/2007 by the then manager and assistant manager. During the said course of inquiry, it was further found out it was the purchaser of the scrap, one Sri Dasarath Shaw, was also inquired into, who admitted purchase of scrap as well as payment of 75,000 in lieu thereof. Upon the inquiry being, upon the preliminary inquiry being done, the manager of Borjan Tea State, being not satisfied with the explanations so given by the delinquent workman, issued a show cause notice to him. On 13/8/2007, alleging inter alia that the delinquent employee had collected an amount of rupees 75,000 from Sri Dasarath Shaw as the proceeds of the sale, scrap sale, but had deposited only an amount of rupees 1,932 with the head clerk. It was alleged in the said show cause notice that the said delinquent employee had been sending out company's property from the factory premises under his signature without the knowledge of the management. Further to that, there were various other, 7 more instances were mentioned in the said show cause notice. Whereby there was sale of scrap, but the entire amount of the sale was not deposited. It is under such circumstances, the delinquent employee was asked to submit a written explanation as to why actions should not be taken, taking into account that he's taking into account that the act that the petitioner, that the delinquent employee had committed a serious offense under clause 10 bracket A bracket 2 all caps of the standing orders. These are standing orders of the standing orders. The delinquent employee was also suspended on the basis of the said show cause notice. It further appears that the delinquent employee submitted a reply, detailed reply on 28/2007. From a perusal of the said reply, it is clear that there is no denial that the delinquent employee received the amount from the said Dasarat Shah totaling to rupees 75,000, as well as the delinquent employee had only deposited an amount of rupees 1,932 before the head clerk. Against the sale of the scrap. However, it is the specific case of the delinquent employee that the said amount of rupees 75,000 was given to the manager, the then manager of the tea state, who handed it over to the factory manager, and the factory manager gave him an amount of rupees 1,932 to be deposited before the head clerk. Therefore, the specific question is next. The said inquiry being the said reply that the management, the management of the tea state in question, having found that the reply submitted by the delinquent workman was not satisfactory, initiated inquiry proceedings by appointing an inquiry officer. In the said inquiry proceedings, the management adduce witnesses of, how many witnesses?
5 minutes.
Huh?
5 witnesses.
Adduce 5 witnesses,
I'm sorry, my 7 witnesses.
Huh?
7, my 7.
7 witnesses. No, in the inquiry proceedings, not before the labor court, inquiry proceeding.
Very positive 5. Yes.
5, na?
Before labor court 7.
Use the evidence of 5 witnesses. And however, the delinquent workman did not adduce any witness, any evidence. The learned, the inquiry officer, on the basis of the documents as well as the evidence on record, frame 9 points for consideration. It is, however, relevant to take note of that in the said inquiry proceeding, the delinquent workman did not raise any issue as regards non-receipt of the list of witnesses, as well as also that had taken any steps for calling the then manager as well as the assistant, as well as the factory manager, whom the workman, the delinquent workman, alleges had misappropriated the amount of rupees 73,000, 75,000 minus 1,19,32 minus 73,000. Be it as it may, the inquiry officer submitted a report on 5/1/2008 whereby it was opined that the delinquent workman was guilty of misconduct. This court, however, finds it relevant to observe that in the said inquiry proceeding, the inquiry officer had also opined that he had reasons to believe that the entire sale matter was wrapped in a shroud of mystery. Inasmuch as shroud of mystery, shroud of mystery, taking into account the stand, taking into account the evidence so produced, which showed some involvement of not only the petitioner, the delinquent employee, but also the management, but also the assistant manager, Sri Ankur Jyoti Sharma, and the then manager, Sri S. Das. Ankur Jyoti Sharma's evidence was recorded, na?
Record.
What did he say?
He, before domestic inquiry, he is MW3. But not before.
No, it's okay, but what did he say in his domestic inquiry? Did the AR consider
Yes,
it?
my lord.
PW3, who also participated in the translation demand factory in Man, had stated that the sale to be recorded in Man were directly deposited to the head clerk by Sri Varan Gogoi. It is relevant, however, to mention that during the said inquiry proceedings, the assistant manager, the then assistant manager, denied the stand, denied the stand of the delinquent employee and deposed before the inquiry proceedings. Stating inter alia that the sale proceeds recorded in the sale statement were directly deposited to the head clerk by the delinquent workman. This court have also perused his cross-examination. Perused the cross-examination of Sri Ankur Jyoti Sharma, the then assistant manager, by the delinquent workman. But nothing could be culled out. To show that the then assistant manager, upon whom allegations have been made by the delinquent employee, had any role in the non-depositing of the 75,000 to the head clerk. This court further finds it further reveals from the record that upon the said inquiry report being submitted on 5/1/2008, On 5/2/2008, the said inquiry report was furnished to the petitioner, to the delinquent employee. And the second show cause notice was issued. The delinquent employee, however, did not reply to the same. The management of the respondent number one, that is the management of Borzanti State, through its manager, by the order dated 7/3/2008, by the communication dated 7/3/2008, dismissed the delinquent employee with effect from 7/3/2008. And further informed the delinquent employee that he shall not be entitled to the benefits, any other benefits and facilities of the company, taking into account that he is no longer in service. Pursuant thereto, next. Pursuant to the dismissal of the employee, the government of Assam referred the dispute to the Learned Labour Court of Assam at Dibrugarh by notification number GLR/215/2008/13 dated 18/12/2008 for adjudication of the issues formulated. Page number 4 repetition 1 and 2. I'll put it up. It further reveals from the LCR that the petitioner filed the written statement on behalf of the delinquent employee and workman, and the respondent number one had also filed the written statement. Before further proceeding, this court deems it proper, take note of that in the written statement filed by the petitioner, the inquiry proceedings were questioned on the ground that the management failed to enclose the list of witnesses to be examined in the inquiry. And also that the inquiry was bad for non-examination of the ex-manager of the garden, Sri S. Das, and the production of the original records, bracket, gate, passbook, etc. It was alleged in the said written statement that the ex-manager of the garden, Sri S. Das, was a material witness, and the production of the original records, bracket, gate, passbook, etc., were not allowed by the inquiry officer for best reasons known to the management. Further to that, the inquiry report was also assailed on the ground that the findings are perverse and there being no materials on record on the basis of which the inquiry officer could have arrived at the said finding. Next. During the reference proceedings, the management adduced the evidence of 7 witnesses. And the workman. And the delinquent workman was the sole witness on behalf of the petitioner. The Learned Labour Court, by the award dated 27th of December 2010, answered the reference in favor of the respondent number 1, thereby upholding the dismissal of the workman, delinquent workman, in doing so, the Learned Labour Court decided the question as regards the fairness of the inquiry and came to a fairness of the inquiry as well as regards the perversity of the inquiry, perversity in the findings of the inquiry officer, and came to a definitive conclusion that the inquiry was held by following the due procedure and there was no perversity in the findings of the inquiry officer. As regards the list of witnesses not being supplied, the Learned Labour Court, taking into account the evidence as well as the pleadings, came to an opinion, taking into account the pleadings as well as the evidence of the workmen, came to an opinion that no prejudice could be shown. No prejudice was sought. No prejudice was shown by the workmen for not supplying the list of witnesses. And accordingly, applying the law as laid down by this court as well as the Supreme Court, held that the delinquent workman was not prejudiced for non-supply of the list of witnesses. On the question as regards the material witness, Mr. S. Das, the then manager, being not produced as a witness, as well as some original documents were not placed. The Learned Labour Court came to an opinion that the delinquent workman during the proceedings before the inquiry officer did not cite the then manager as a witness. As well as also could not show the relevancy as regards the original gate pass. The Learned Labour Court further, taking into account that the allegations against the petitioner did constitute misappropriation of the company's property, which was a serious misconduct, which was a great misconduct, entailing loss of confidence of the employer, did not find any reason to interfere with the order of dismissal of the delinquent employee. The petitioner herein being aggrieved by the said award dated 27/12/2010 had approached this court by filing a writ petition, by filing the present writ petition on 15th of September 2011. It reveals from the records that by an order dated 21/11/2011, this court had issued rule it further reveals that the respondent number 1 had also filed an affidavit in opposition on 6th of August 2008, on 9th of August 2018, supporting the award so passed, the award so impugned in the instant proceedings. This court have duly perused the materials on record and heard the learned counsels for the parties. Before further proceeding, before proceeding to deal with the respective contentions so submitted, this court finds it proper to take note of a judgment of the Supreme Court in the case of APSRTC versus Raghuda Siva Sankar Prasad, reported in 2007, 1 SCC 222. Wherein the contours of the jurisdiction under Article 2 to 6 of the Constitution was dealt with. Paragraph number 20 to 23 being of the said judgment being relevant is reproduced hereunder. In the backdrop of the above law as laid down, let this court therefore consider as to whether the impugned award dated 27 dated 27/12/2010 requires an interference by this court next. The facts as stated herein above is clear to the effect that there is a clear admission on the part of the delinquent workman that the scrap of a value of rupees 75,000 was sold to one Darsnath Shaw. And the said Darsnath Shaw had paid the said amount to the delinquent employee and workman. It is the case of the delinquent employee and workman that he, upon receipt of the said amount of rupees 75,000, handed it over to the manager and the manager and the then manager, along with the assistant manager, misappropriated the said amount and only handed to him an amount of rupees 1932, which the delinquent workman deposited before the head clerk. The fact that the delinquent workman had only deposited 1932 pursuant to the receipt of rupees 75,000 is an admitted fact, as could be seen from the show cause reply submitted by the delinquent employee himself, workman himself. The question, therefore, is as to whether the workman could prove that the amount of rupees 75,000 was handed it over to the then manager, who, along with the assistant manager, misappropriated the said amount, save and accept, handed over rupees 1932 to the petitioner, to the delinquent employee, workman. This court have duly perused the evidence, have duly perused the evidence so taken during the inquiry proceedings, as well as also the evidence before the learned labor court. The delinquent workman, as well as the petitioner herein, completely failed to prove that the delinquent employee handed over the amount of rupees 75,000 to the then manager, and that he was only returned, he was only given rupees 1932 to be deposited before the head clerk. This has been done by a fact-finding inquiry. But this has been done in a fact-finding proceedings, both by the domestic tribunal as well as by the learned labor court. Under such circumstances, the submissions so made by the learned counsel for the petitioner, Mrs. A. Bhattacharjee, to the effect that the inquiry proceedings, domestic inquiry proceedings, as well as the proceedings, the report of the domestic inquiry, as well as the learned labor award passed by the learned labor court is perverse. In the opinion of this court, is misconceived. This court further finds it relevant to take note of the award, wherein also the learned labor court had in great detail discussed the question of fairness of the domestic inquiry and came to a finding that the domestic inquiry was held as per the procedure of law and by following due fairness. Taking into account the said, which this court, upon perusal of the records, finds no reasons to differ. It is the opinion of this court that the inquiry so held, the domestic inquiry so held, was also fair by giving due opportunity to the petitioner, to the workman, delinquent worker. The third aspect of the matter, which also requires to be taken note of, is as regards the proportionality and as regards as to whether the charges proved was proportionate to the punishment of dismissal upon the petitioner, upon the delinquent workman. This court, no, the Learned Labor Court had also duly taken note of the same, wherein it has been observed that as the charges of misconduct, that is misappropriation, has been duly proved against the petitioner, against the delinquent employee, it would result in loss of confidence. And as such, the question of interfering with the dismissal of the workman by order dated 7/3/2008 was not warranted. This court also, taking into account the charges which have been proved, and this court finding no perversity in the same, is also of the opinion that on account of the loss of confidence, the management of the Borjan Tea Estate, that is the respondent number 1, was justified in dismissing the petitioner, the delinquent workman, by the order dated 7/3/2008. In that view of the matter, this court finds no reasons to interfere with the judgment, with the award dated so and so, for which the instant petition stands dismissed. The records, the registry is directed to forthwith return the records to the Learned Labor Court.
Published.
Person list, item number 1.
In this matter, Mr. PN Goswami is appearing. He's
Huh?
on legs, Your Lordship. Court number PN Goswami, additional agent. He's on legs in court number 1.
This is PN Goswami. What is PN
Sorry,
Goswami
sorry,
doing?
Lordship. I thought this is the top of the list matter.
No. Yes, who is appearing here? Revenue? Yes. Yes, madam, tell me.
Yes, Lordship. Petitioner's father was running a shop, tea stall in the premises of the settlement officer from prior to 1974. In the year 1974, he and revenue was assessed by the additional deputy commissioner Dibrugarh, which is annexure 1, Lordship. May I read the vernacular, Lordship?
Annexure?
1, Lordship. Upayukta Mohodar Ade,
Is legal aid.
yes, Lordship.
Okay, tell me. This is caste certificate, annexure 1.
Yes, oh, sorry, Lordship, it's annexure 2, Lordship. I apologize, Lordship, it's annexure 2.
Yes,
Uh,
1974.
Yes, Lordship. উপায়ুক্ত মহোদয় আদেশ অনুসৰি বন্দোবস্ত প্ৰাধিকৰণৰ কাৰ্যালয়ত চৌহদত ভিতৰত থকা আপোনাৰ চাহ মিঠাইৰ দোকানখন দোকান 1200 বৰ্গফুট মাটিৰ খাজনা প্ৰতি বছৰ 95 টকা 40 পইচা হিচাপত ধাৰ্য কৰা হ'ল। উক্ত খাজনাৰ টকা জমা দিয়াৰ ট্ৰেজাৰী জমা দিয়াৰ টকা দিয়াৰ ট্ৰেজাৰী চালান কাৰ্যালয়ত 30/11/94 তাৰিখৰ ভিতৰত দাখিল কৰে। So it seems then they are paying the revenue, and the revenue was subsequently enhanced, Lordship. The enhanced by the circle officer, and which is annexure 4, Lordship. Then he is continuously paying the revenue, Lordship. It's annexure 5, continuously paying the revenue for running, and now initially it was given in the name of the father of the petitioner. Subsequently, the father of the petitioner on 19/11/1996, he expired, and thereafter the petitioner is running the said tea stall. And Lordship, he was served with a notice by the circle
What
officer.
is this? 1974, he has been there doing out there for 50 years. One fine morning, you wake up. No, we are going to throw him out. What is this?
For a moment, my lord, may kindly come to page 26. He appears to be a permissive occupier.
Whatever it may be, if it is a permissive occupier, that means it is a better case for him.
Yes, sir.
Don't you think so? Wouldn't the rule 16 then come in that the deputy commissioner allowed him to stay?
My lord,
Yeah.
yeah, bringing it. Page 26.
Yes, I've seen it.
This is, my lord, being, kindly see, my lord, the remittance to authority being revenue in respect of rent.
Hmm.
So it is rent.
Hmm.
So they are not settled with that plot of land. That's why I made.
Understood. So if it is a
That's why I made
rent,
submission permissive occupier.
so if it is a permissible occupier, meaning thereby wouldn't he come under 16 and say that otherwise a person normally cannot unless he has been given on specific orders by the deputy commissioner. Now the deputy commissioner has allowed it by this 1974. How can you exercise 18?
Oh, my lord, that is too long. I am not on that event, my lord.
That's his father's, my lord,
Page
not
26.
his.
What?
That's his father's. Page 20 is his father's, not his. That is not in his name, it's
So?
in his father's name.
So father, would they leave up everything after the father died? He's working out there for all this while.
74, it is a too long story, my lord. I am not on that. I
Well.
am from, my lord, page 26, matter gets clear.
Hmm.
So therefore, I have made that submission that he is a permissive occupier. Admittedly, record shows, my lord. I cannot deviate from it. Then my lord will kindly come to page 35. That is the impugn notice.
Hmm.
ইয়াৰ দ্বাৰাই আপোনাক জনোৱা যায় যে ডিব্ৰুগড় মৌজা অন্তৰ্গত কলিয়ামাৰী ৱাৰ্ডৰ 21 নম্বৰ চৰকাৰী ডাক কাইণ্ডলি মাৰ্কেট চৰকাৰী ডাকত পূব ৰাজহ চক্ৰ কাৰ্যালয়ৰ নামে থকা ডাকৰ অংশত থকা ঘৰ বাৰী চাহভাতৰ হোটেল খুলি অবৈধভাৱে দখল কৰি আছে। গতিকে এই জাননীৰ জৰিয়তে 15 আগষ্ট 2023 তাৰিখৰ আগতে আপোনালোকক বেদখল এৰি দিবলৈ জনোৱা হ'ল, অন্যথা বিধিগতভাৱে আইনী ব্যৱস্থা গ্ৰহণ কৰা হ'ব। Now, two things flows from here. Admittedly, authorities, my lord, these documents show, of course, that on facts, I will have to obtain instruction. What is the veracity
That
of
1200 square feet you cannot touch. Remaining, if you want to do, because here there is no schedule.
schedule, but it is already there, my lord.
Understood, it is in Dag. Are you saying that 21 Dag is on, Dag number 21 has only 1200?
What I perceive from
Because if you see all the other rent receipts, these are for this tea stall for 1200 square feet.
1200 square feet.
If it is more than that, you can do, but not 1200.
Yes, principle of the
Because there is nothing mentioned out here as regards to this. You should have been more careful issuing all these things. Okay. Issue notice
will
when?
confine the interim protection only to 1200 square feet.
Yes, only
As it-
1200. huh?
Yes,
My lord, as it transpires from this page 26 NHF, I think.
No,
Yes,
anyway, but this is 1200. Only 1200, madam.
Yes, lordship. Yes, lordship. From 74 on law, 1200.
Whatever, 1200.
Yes.
When? Instructions? Not instructions. Yes. When?
Monday, but
Not Monday.
Lordship
You
will
don't
kind-
have time.
No, lordship, what I am saying.
October?
No, not October. Lordship will kindly issue a short notice of motion.
Why?
Let the circle officer file an affidavit on facts, my lord. Things will be clear.
Yes, my lord.
We cannot improve the case, my lord, on facts. Whatever is there is there. Lordship will be on-
We are on live streaming. So it is very nice nowadays. These are all recorded. We shall play this live streaming record whenever you otherwise say that it will take we want 2 weeks time.
Lordship will issue a short notice of motion.
Okay. Today is what date?
Today is 8th, lordship.
Okay. Issue notice making it returnable on 21st of August 2023.
My lord.
Mr. Arbor Pujari appears on behalf of the respondent number 1.
One.
Ms. S. Sharma appears for the respondent number 2 and 3. As the respondents are duly represented, extra copies of the writ petition be served upon them during the course of the day.
Yes.
In the case of the petitioner herein is that the father of the petitioner was permitted to run a tea stall on a 1,200 square feet land in the premises of the office of the settlement officer. This aspect of the matter could be seen from the communication dated 14/11/1974 issued by the then Assistant Deputy Commissioner Dibrugarh. It further reveals from the records that the petitioner continued to remain in the said stall, run the said stall measuring 1,200 square feet and had all along been paying the revenue, rent. It's a rent or revenue.
Revenue lordship,
Where?
being revenue in respect
Revenue
of.
of your
rent.
stall.
But,
It is a rent actually.
Yes, that's-
Rent,
No, no, not
Seven-
revenue.
it is rent. You have.
Yes, lordship, but in
It's
the
revenue.
74
Had-
notice, it's revenue.
At page, you only, these are documents, madam,
Yes.
madam,
Yes,
page
yes.
29.
Yes.
You yourself say being revenue in respect of rent,
Yes, lord.
had continued to pay the rent to the continued to pay the rent by way of a treasury challan. Since then, till date. It further it is further seen that the said rent have also been increased in the meantime. Is it 95 or what?
Now it's 110 lordship. Initially, it was 95, 95 for 40 paisa. As per
Have also
annexure
been
two.
increased in the meantime.
Latest it is 330 rupees.
But that is for 3 years.
Yes, ma'am.
8, 9, 10, 11. That is 4 years.
110.
110 appears to be the annual rate. 110.
110.
110.
Uh, how are you saying that 110? 2008, 9, 10, 11. You are saying from year 2008 to 11,
Page 26,
page 33.
page 33. Yes,
2008, 2009, 2010, 2011.
yes, it's 3 years. That means-
How is it 3 years? Why are you subtracting?
No, no, I'm not. 8, 9, 11, 4 years. 4
It's 4 years.
Yes.
4 years.
Four
But
years.
annexure 5, page 26 is 110 lordship for 17-18 means 1 financial year.
Less than 100 rupees.
Have been increased in the meantime. Be that as it may, the circle officer revenue, this Dibrugarh Revenue East Revenue Circle had issued a notice on 31/7/2023 directing the petitioner to vacate the tea stall. To vacate the place before 15th of August 2023. And it is under such circumstances the incident writ petition has been filed. This court, upon hearing the learned counsels for the parties and taking into account that the petitioner was allowed to run his tea stall in a 1,200 square feet area, and the authorities continued to receive the rent, the exercise of the jurisdiction by the circle officer, Dibrugarh Revenue East Revenue Circle, by the communication dated 31/7/2023, in the prima facie opinion of this court is contrary to the provisions of the Land and Revenue Regulations, Assam Land and 1886, and the rules framed therein under. This court also finds it relevant to take note of that the said notice dated 31/7/2023 impugned in the incident proceedings is not clear as to what is the exact area from where the petitioner is sought to be evicted. Taking into account that the petitioner was allowed and permitted to run the tea stall in an area measuring 1,200 square feet, this court therefore directs the respondent authorities not to disturb the possession of the petitioner in respect of the 1,200 square feet of area wherein the petitioner has the tea stall till the next day. The Ms. S. Sharma, the learned counsel, appearing on behalf of the respondent number 2 and 3, shall apprise the deputy commissioner as well as the circle officer concerned, that is the respondent number 2 and 3, about the order passed today forthwith.
Timing item 5.
Infractions matter, my lord. Infractions.
Infractions. Mr. G. Pegu, appearing on behalf of the respondent, submits that the instant writ petition has been infructuous in as much as the monthly salary for the period from July 2009 to January 2010 amounting to rupees 2,30,000 and 60% area of the 6 CPC amounting to rupees 1,54,557 have already been paid. In that regard, he has submitted an instruction issued by the Deputy Chief Law Officer, which is dated 12/9/2016, which is kept on record and marked with the letter X. Taking into account the above, the instant writ petition, therefore, taking into account the prayer, the relief sought for in the instant writ petition, which have been duly granted, as stated in the instruction marked with the letter X, the instant writ petition stands closed as it has become infructuous.
Timing item 1.
Yes,
Absolutely. FIR is at page number 17, the repetition, my lord.
yes, Mr. Gustami.
My lord, petitioner has said that he was a juvenile and he was detained illegally. But that point was raised before the Honorable Trial Court, man. And Honorable Trial Court decided and it was found to be juvenile and he was sent to juvenile house, my lord. So
Understood, but why did you keep him for 4 months or 3 months?
it was under the orders of the court, my lord. That he was immediately produced in the judicial custody. He was not sent to any police custody also. And he never raised any point while he was produced or he was arrested that he was a juvenile. He raised this point before the trial court, my lord. Then trial court, even he submitted some applications which were not found to be acceptable. Then trial court sent him for medical examination. In the medical examination, it was found that he was juvenile. Then accordingly, necessary actions were taken. And my instruction to this is that, my lord, there was one co-accused, my lord. He accepted his guilt and he was imprisoned for 5 years. Now the proceeding is before, his proceeding is before the juvenile board, which is being handled by additional citizen Difu. So there is no fault on the part of the state authorities, my lord.
What?
We arrested him. We produced before, immediately next day we produced before him to the court. He
When
never
do you decide when a person has to be juvenile or not?
physically, my lord, if we could physically ascertain that he maybe is juvenile, my lord, then this exercise would have been done by us, my lord. He himself said, my lord, he is 18 years age.
When?
While he was arrested, my lord. That's
Show
why, my
me
lord,
that.
We have made a statement in the affidavit, my lord.
No, you have made a statement in the affidavit, it is very good, but where is it? Yes, stated. Why will you state? I am 18 years old and as such put me behind bars. Yes, why will you
Sir,
say
the
that?
point of being juvenile, my lord, was raised later on before trial court, my lord.
No, then at
Okay,
the time when you are arresting him, are you not required to put his age?
you have put age as
Why
18.
did you put the age? Have you looked into it?
Page
That
number
he
21.
looked out there that he was 18 years?
Page number 20.
I would difference. There's a difference between a 14-year
Page four-
physical appearance of 14 years and 18 years.
My lord, may kindly peruse paragraph 4 of my affidavit, my lord, our affidavit, filed on 16th of February 2015. There are two affidavits, my lord. It's the first one, 16th
Yeah.
February 2025.
That and to the
Paragraph
that
4, my lord.
since within 1 week, some unknown person stolen away the ejected telephone and the strength of the minors and the EHS have been- Let's see the forwarding report.
Forwarding report is a page, my lord.
Page 21, my lord.
Page 20, it starts, my lord.
20 is translated.
No, 20 was also,
21. 20
also furnished.
21.
Followed by Handwritten.
What is the name of the juvenile?
Rohit Mess.
Huh?
Rohit Mess.
The accused so and so confirmed that he accompanied by co-accused so and so. Yes, 300
My lord, may kindly peruse page 22, my lord. He was, my lord, arrested on 19/4/2014.
Who has given you this information that he was 18 years?
My lord, initially, as per our affidavit stand taken on affidavit, my lord, initially petitioner disclosed him his age to be 19. His father, grandfather came to the police station. He stated that it is not 19, it is 18. My lord, kindly see page 20 and 21. 21 is dated 19/4/2014.
That the arrested minor alleged to have medically examined at the time of arrest. And whose activity is this?
So this was by,
Oh, this is the petitioner. Okay, okay.
my lord, there is an affidavit by Superintendent of Police,
Your paragraph. Yes.
paragraph 3, my lord.
Father
5.
who is accused in who is prisoner number 2 is accused in
Paragraph 5 of our affidavit, my lord. At page 2, my lord.
Let's see the Juvenile Justice Act. What does it say?
Section 94, my lord.
Hmm.
Section 2L defines juvenile in conflict with law.
Section
2L, my lord. We'll have to refer to the old act, my lord. At the time of cause of action, the old act prevailed.
We are not disputing that now he's juvenile or not, my lord.
Juvenile Justice, Care and Protection of Children Act 2000, my lord. 2L, my
2000.
lord.
Where is the 2000 Act?
2000 Act, my lord.
Give it to me.
This was subsequently repealed in 2015.
2000.
2L, my lord. Section 2L.
Uh,
Section 2L, my lord. Definition, my lord.
Juvenile in conflict with law
Law.
means a juvenile who is alleged to have committed an offense and had not completed 18 years as on the date of commission of the crime. Now, that is okay.
And
Now, how
if your
how it is being taken?
My lord, if your lordship kindly takes section 10 for a moment of the same act.
Ah.
My lord. It says, section 10, my lord,
Ah.
apprehension of juvenile in conflict with law. As soon as a juvenile in conflict with law is apprehended by police, he shall be placed under the charge of the special juvenile police unit or the designated police officer, who shall produce the juvenile before the board without any loss of time, but within a period of 24 hours of his apprehension, excluding the time necessary for the journey from the place where the juvenile was apprehended to the board, provided that in no case a juvenile in conflict with law shall be placed in a police lockup or lodged in a jail.
No, understood. These are very much. But how at the time of arrest, what is the requirement of the police? Because there might be many persons out there. One may look maybe short out there, he may be 34, but the person who may be tall out there, he may be 12. You never know. How does this ascertaining can be done at the time of arrest?
My lord, as the records have revealed, my lord, this is a boy below 14 years of age. And the conduct, as it has been shown, even in the forwarding report, there was overwriting, man. That is why, my lord, the conduct is very important. If your lordship kindly turns, my lord, the forwarding report at page number 21, your lordship will see page number 21, my lord. Now, page number 21, at the bottom, my lord, name and address of the accused, my lord, Shri Rohit Mas, 18 years. Now that 18, your lordship will see, it doesn't indicate the free flow of a pen. It clearly shows that there has been some kind of tampering, which the authorities have admitted in their affidavit in opposition.
Where is that? Where is the original one? This is a certified copy. Where is the original one?
Page number.
You are appearing for whom? You're a
Statement.
Forest Department Council. What are you doing?
The senior government advocate requested me to appear as additional enemy.
Okay, fantastic. Now, where is the original one?
Original one is with my lord, the court, my lord. Juvenile court, my lord.
Okay, we call it
Additional CJM, DFU. Manja PS case 25 of 2014.
original. These records need to be shown. And who were the persons who were responsible?
My lord, that is a question of fact which probably my learned.
That I will find out, my
senior
lord.
You
will have
find
to
it out
That I will find out. Section
and give the
49 will be-
names.
Section 49 will be relevant, my lord, when there is how to ascertain whether a person is juvenile or not.
49 of the
That
old
two-
act.
2000 Act, my lord.
49, yes.
Presumption and determination of age.
49. And that is what I was asking him.
Where it appears to the competent authority that person brought before it or under any of the provisions of this act, otherwise then for the purpose of giving
Right,
evidence.
this is before the competent authority.
Yes.
We have not, this stage of going to the competent authority did not come.
That's why, my lord, some assertion from the petitioner side is also required that he was arrested in April. He moved an application in July, my lord, after 3 months that I am a juvenile.
First of all, he has to know also, na?
It's an out-
He has to know that these are the protections which are available.
Let records come, my lord. That will be better.
Because if you see, normally, there are a lot of people who may not know
No.
that
that's
these are
true.
the
That's true.
advantages of being a juvenile. What is the year? So under such a, he may not know that it is when Mr. Borwa must have been in contact, then he must have.
Let record-
enlighten that
Actually,
so and so for filing.
Usually,
Oh, yeah,
Usually,
Mr. Agarwal is there.
usually, my lord, what happens in the forwarding section 50 for arrest memo and inspection report, age is reflected, and one of the witness from the family side is also required to put a signature. If that has been done, my lord, now they cannot say that they were not aware of the age being put as 18, my lord. Let record come, my lord.
Where's the FIR?
FIR is there, my lord.
Page number 17, my lord. Your lordship will see the perversity. Page number 17, the translated, translated version. May I just read out the first 4 lines, my lord?
Wait, 17, huh?
Page number 7. Sir, most respectfully, I beg to state that the cables which were erected on roadside on various lane line of Dimapur, Nagaon and Difu were stolen away by unknown persons
Within a week.
within a week.
There are two
No.
accused, my lord. One has confessed his guilt. He has been
Based on
punished.
such an vague affair, immediately the minor boy was picked up.
Oh,
They have not tried for medically examined.
And the forwarding indicates at page number 21, the age of the minor was put as 18.
Hmm?
Page 21, my lord, the forwarding, the age of the petitioner, it was put as 18.
That we have answered in our affidavit, my lord. We initially put as 19 on his statement.
the-
On the statement of
The
grandfather, we have put as
reply which
18.
has come,
now understood. Those are 18, 19, whatever may be, where grandfather, whatever may be. But isn't it required for them? Because a lot of people may not know.
No, that's true, my lord.
If the person doesn't know, are you not going to inform the authority, this person that about that what was his age and there was something to that effect? That because this is a serious thing. You may catch because a lot of people that may not know that if he's below 18, he can
gets
be
some
very well.
protection. True, my lord.
he's an orphan boy, my lord. He is survived by his grandfather, who is an old rustic villager. That has been pleaded in the writ petition and that has not been, my lord, disputed.
Even, my lord, the court below, my lord, did not accept the birth certificate and send him for medical examination. Page 22, my
And
lord.
my lord,
Did not accept the.
Birth certificate, my lord. Page 22.
Now there is one section now. What is that section out here?
Now it-
How it is to be ascertained, and there is a Supreme Court judgment.
Now
now.
it is
Is there, my
section
lord.
94 under the present act.
Supreme Court, my lord, this one judgment, I've made. a
That
small
Supreme Court
compilation.
judgment, how the age has to be ascertained.
Right.
My lord, has act-
I'll just point out the relevant. The Subramaniam Swami judgment, my lord, if your lordship kindly turns to page 114. 114 of the compilation, my lord. It's a judgment of Subramaniam Swami, that judgment, famous judgment, my lord. The differences between page number 114 running page, the differences between a juvenile justice system and a criminal justice system has been enumerated. It says, FIR and charge sheet in respect of juvenile offenders is filed only in serious cases where adult punishment exceeds 7 years. A juvenile in conflict with the law
Oh
is
no, Mr. Burwa, you are going into all this thing. I'm not on that. There is a one judgment.
Very recently one has come.
It has been stated how it can be done.
P. Yuva Prakash, man.
Huh?
P. Yuva Prakash, very recently one has come.
Yeah.
P. Yuva Prakash.
Oh, to that also. That has followed that judgment. That how you can't send the person to a medical examination on the way. You have to look into what other things. First of all, that judgment which you are referring to is a judgment pertaining to the high school living certificate.
My lord, yes, man.
And say that no, you can't rely on the high school. But what is to be done? There is one judgment. In fact, I had dealt with a pastor judge order out there in Arunachal, Itanagar bench. I think that is reported, that judgment. I forgot. That is the main judgment. Why you are giving me a voluminous book of all these
I'll
things?
just, on the next day.
That has been clearly mentioned. How the age has to be determined.
Well, under the
You
2000
can't determine the age. Some section 7 or
section
something.
94, my lord, 2015 act.
No,
my lord.
no. Huh?
Section 94 of 2015 act, my lord. It, my lord, prescribes the manner in which the age is to be ascertained.
In section of the 2015 Act.
15
no,
Act.
No. It was an old act.
And 2000 act, my lord, it is 49, my lord.
49. No, not 49. 49 is different, but there is manner in which it is given. From here, this will happen. This. Now, see the rules. Where the rules?
94.
Old rules?
Hmm.
You have the old rules?
I should have told you. Yes, ma'am.
Old rules, do you have it?
Yes, ma'am.
As per the 2000 Act, there's a rule.
Old rule, my lord, rule of 2007,
Ah.
section, rule 12, my lord.
That.
In every case concerning a child or a juvenile in conflict with law, the court or the board, or as the case may be the committee, referred to in rule 19 of these rules shall determine the age of such juvenile or child or a juvenile in conflict with law within a period of 30 days from the date of making an application for that purpose. The court or the board, as the case may be, by the committee shall decide the juvenility or otherwise of the juvenile or the child, or as the case may be, the juvenile in conflict with law, prima facie on the basis of physical appearance or document,
Yeah.
if available, and send him to the observation home or in jail. In every case concerning a child or juvenile in conflict with law, the age determination inquiry shall be conducted by the court or the board, as the case may be, by the committee, by seeking the evidence by obtaining, number one, the matriculation or equivalent certificates, if available, and in the absence whereof, the date of birth certificate from the school other than a play school first attended, or in the absence whereof, the birth certificate given by a corporation or a municipal authority or panchayat, or only in the absence of either 1, 2, 3, and 4 above, the
Medical.
medical opinion.
But
But
why
that is
did the
precise-
court go for medical immediately?
Well, that is precisely the section 94 of 2015 Act. Madam. Same,
No,
very
no,
clear.
94, it is okay, but this is what
Yes.
you have to do it in this manner.
Here in this case, well, they made an application before on trial court. Well, trial court.
No, on the day on which it was produced before the trial court should have taken that point
Exactly.
itself.
That is what I'm saying, my lord.
But provided in the trial court take into action that aspect of the matter.
If my
we'll
lord,
have
there is a space 23
Okay.
of the writ.
heard the matter. Upon hearing the learned counsel for the party, this court is of the opinion that for deciding the dispute, the forwarding report in original
Well, enter case record be called from. There will be arrest memo also, my lord. And
the case record pertaining to what is the case
Anja
number?
PS case number 25 of 2014, pending before additional CJM default.
Would be required to be perused. Under such circumstances, this court directs the registry to forthwith call for the original case records of so and so. I think it is charge sheeted.
No, the other person is succeeded,
So
punished.
there will be a
It is
case number
Our
there.
information is that it is pending there, my lord. Case number
So there will be a case number there.
from Manja PS case also, they can find it out, my lord. They can trace it
No,
out.
no,
my lord.
no. They,
Court-
you are-
okay, there will
when
be
you are
court-
asking that code, it would be very difficult. You have to give me the case number. What is the case number?
That, my
Case
lord,
number,
After that, charge sheet or in your case, there must be some case number out there in the juvenile court.
my lord, I'll just,
I don't know. Later when it was forwarded to juvenile court.
case number is not there, only the orders are there.
No, there will be some case number
Yes,
in the
yes.
juvenile
Yes,
court.
my lord.
GR number is there, my lord, 313.
Ah,
of
GR
14.
number.
GR number, my lord, 313 of 14, my lord, public 14.
The original case records of GR case number 313/2014, which is in relation to Manja PS case number so and so, presently pending before the court of the additional chief judicial magistrate,
Default Kargan.
Difu Karbianga, would be required to be perused. So taking into account the same, the registry is directed to requisition the original case records above mentioned and list the matter on 14th of September 2023.
Public.
Along with all the necessary documents in the taking into account that the incident writ petition is of the year 2015, this court requests the commission to submit their report as expeditiously as possible and preferably by 7th of September 2023.
Right.
List the matter again on 11th, 12th of September. So the registry is also directed to communicate this order to the learned members of the commission.
I have some personal difficulty during that week. Your
On
during that week, I'm not there. Some the subsequent week, 19th, 20th, 21st, 20th, 21st, 22nd, any day.
let us see. We have asked them to submit the report.
Submit the
We'll take care of it.
report.
Lovely.
I number 8 and 9 for orders.
He could be 14 or actually kita low long. 13 to do. Yes, Mr. Dave, what is your matter about?
My lord, in this case, my lord, simply my lord, TP was not extensive, transit pass has not been issued to the
Huh?
petition. Transit pass, he has collected some materials that is Padgila bark. And earlier it was issued to him to transport it to outside the ashram, but subsequently it is stopped. And all the materials collected by the petitioner has been taken into custody. Since 2013, my lord, those Padgila barks collected by the petitioner is in the custody of the respondent authorities. My
This
lord,
is regarding the Bagila barks. What is that?
my lord, this is the bark. Trees, my lord, bark is collected to use generally for some medicinal purpose.
And the forest is not allowing it.
Forest, my lord, he has collected from the revenue villages after taking permission.
Then
And thereafter, he also permission is given to transport outside the ashram. Subsequently, it is stopped, my lord. My lord, I have prepared
now
the
what do
list.
you say about the it requires an approved working plan?
Lord,
There's a requirement of having an approved working plan for transport, removal and transport of any tree bark. With
my lord,
you have a approved working plan.
working plan, my lord, that is not here. Actually, my lord, from revenue villages, my lord, kindly see the permission given by the authority, my lord. That is, my lord, I have prepared the list of dates. After proper verification, my lord, petitioner was allowed to
Yes, Mrs. Chaudhary.
collect
Ms.
the
Chaudhary,
particular bark.
you were not there when the matter is called. What is there? Does anything remain? Item number 2. Okay. What about 9? You got to stay somewhere? Okay. What is the writ petition?
WPC 6204 of 21. And another,
Pursuant to this case,
yes,
did you get any stay anywhere?
yes, Lordship. In both these cases, there is a stay order.
This is as regards eviction. This IA was for eviction.
Yes, Lordship.
Then did you get a stay somewhere?
Lordship, after that, actually, we filed a substantive writ petition, and that was listed before Justice Shyam today. And we got a interim order.
Miss P. Chaudhary, appearing on behalf of the petitioner, commits that she would not like to press the instant writ application. Taking into account the above, the instant writ application stands closed on withdrawal. Undertaking so given earlier. Hence. Closed.
And Lordship, the other two writ petitions, the interim order.
Interim order is still too late.
No, Lordship, since it was distant, so I have.
If it is not there, I won't. This matter has only come for today.
Yes. Yes. Great. Much appreciated.
I am for the respondent.
Give your name. Yes.
My lord, my case is that my lord petitioner initially applied for submitted an application for allow him to collect the Badgila barks from the revenue villages, particularly from Kuklung Ranch and Amteka Ranch of PTC. And that application was allowed, my lord. My lord, that is Annexure 3, my lord. And allowed to collect the Badgila barks from the revenue villages by maintaining a procedure. And by maintaining the procedure, he has collected the Badgila barks from the revenue villages. And subsequently, my lord, he was allowed to lift.
What is this order being passed in WPC number 202 of 95?
This is Goda Burman.
Ah.
It's still continuing, my lord. There was a direction I'm placing the.
So there is a ban.
Here's a pen, my lord. Any timber, auction timber and legal timber has to go by railways, my lord. It cannot be taken out, my lord, with by other sort of vehicle, my lord.
Now, these documents, Conservator of Forest, Annexure 1, page 7 of the affidavit filed by the PTC.
It's still in operation, madam. I hold the judgment also.
So they can't take it like this.
No, madam. They cannot take it.
No, that is with respect to trees, not
No,
bark.
it also says about barks.
And from the forest, but I have collected from the
Action
revenue
and
villages.
conservation of forest interim orders already passed by the having regard to protection and
98.
auction timber as well as legal timber, including for timber outside ordinance shall be. No, this is not that. What is this order they are mentioning out there? This is of 2012. No, this is of 1998 you are bringing. There's some order passed in 2012. Why you have issued this communication by the conservator of forest?
Order. It's 98, my lord. I have to go back because, my lord, this is still continuing. Goda Burman is still continuing, my lord. The petition,
Understood, but what is your basis on issuing? Because this is the document on which he is not being allowed.
my lord.
Isn't it?
My lord, that is
So
the,
we have to see that this, because that document, that mention which we are mentioning is only as regard trees, timber. Timber and barks are different.
different.
And here you are saying that no bark of any tree is allowed for transportation as per the orders of the Honorable Supreme Court in W so and so and orders of the principals so and so. Special attention should be made for stopping of transportation of the bark of so and so, so and so, so and. What is the basis of this order?
But it,
Show me that the
it
order of
also
the
refers to
authority.
this,
No, it can't be that.
no, my lord, the parent petition. 2000, it's also WPC 202, my lord.
Understood, but there must be some order.
There must be some order, my lord. I have to go through once, my lord. This file was, actually, is a care, should be taken care by PTC, but my lord, we had been implemented later on, my lord. My lord.
Okay, list the matter again on the. List the matter again on 17th of August.
Very well.
2023,
17. I'll try to catch.
on which
hold of
date
my-
Mr. D. Gogoi, the learned counsel appearing on behalf of the Forest Department shall apprise the basis of the order dated 36/2012 and more particularly as to whether the Supreme Court has passed any order in respect to parts of any tree.
My lord, may, small prayer, my lord. May pray, my lord, it may be fixed on 16th, 17th, I have other matters, my lord, already fixed.
16th is Wednesday, Mr. Kapoor.
Then in other dates, my lord, 17 after 21, my lord,
On 22nd.
26. Always, my lord.
Item 11.
Is your lordship. Because additional advocate general, the point appearing in this matter, my lord. My lord, on the last occasion,
I asked you about as to whether there was an opportunity of hearing given
uh,
prior to as regards the inquiry.
my lord, we have already called for the records of the departmental proceeding from the directorate office, but they have sent the mail that it is not available in the directorate office. So they have communicated with the secretariat, but it needs 1 week more time, my lord, to
It's Kotoki, the learned counsel appearing on behalf of
any dairy development department.
Animal Husbandry and
Veterinary.
Dairy Development Department had submitted that some more time is required for the purpose of getting the records pertaining to the disciplinary proceedings. Taking into account the same, list the matter again on 29th of August 2023. The learned counsel appearing on behalf of the respondent shall ensure that the records are received in the meeting.
Obliged, lordship.
Lordship, last occasion, this instruction has been received from the department. I want to submit.
Now, pursuant thereto, have you passed an order?
No.
Why?
Thereafter, the court, they have not participated till yet.
Understood, they have pursuant to the direction passed by the appellate court, you have issued press notice.
Yes, sir.
They have submitted the reply.
Thereafter, nothing has happened.
Why?
They have not participated, your lordship. Thereafter,
Understood, if they are not possible, take your own call.
we have mentioned in our paragraph, in affidavit in opposition, paragraph number 7.
Understood, what is he challenging out here?
In the, in
The
the,
premises aforesaid so-called mandamus should not be issued to disturb the peaceful possession of the petitioner's plot by passing the order or by passing the order of the learned district judge. Now, pursuant to that, you have issued notice.
yes, sir.
They have submitted reply.
Yes, sir.
You have not taken a call thereafter.
Thereafter, we have not taken because they have come to this before this honorable court.
Okay.
That's the
Chalo.
point. If they come remand back here, then there's nothing more.
It appears from the records that pursuant to the order dated 23/9/2009, 24/9/2009, passed by the learned additional district judge FTC Karimganj in Miss Appeal number 4/2004. Fresh show cause notices were issued to the petitioner on 7/8. How many petitioners?
One please.
To the petitioner on 7/8/2015 oblique 24/8/2015. It is further appears that the petitioner have also submitted a reply. However, the respondent railway authority, the estate officer of the railways have not passed any orders taking into account the pendency of the petition. Taking into account that the provisions of the Public Premises Unauthorized Eviction Act 1971 confers a jurisdiction upon the estate officer to estate officer to take steps in accordance with the provisions of the said act. This court does not find any reason for passing any orders in the instant petition. Be that as it may, this court further makes it clear that the estate officer of the railway shall pass the order by observing the formalities as required under the said Act of 1971. Accordingly, the petition stands not disposed. Interim order, if any, is executed.
Thirteen.
Yes,
This is a petition filed by the APDC against an order passed by the permanent Lok Adalat by which compensation was granted for the death of a person while executing. The primary ground of challenge your lordship is that under the Legal Service Authorities Act, any order passed by the permanent Lok Adalat has to be passed by a quorum of 3 officers, the chairman and 2 other people. This was an order, your lordship, where the chairman passed the order by himself, your lordship. That is the primary ground of challenge.
to me,
The order is at page number, starts at page number 26, your lordship.
page number
26. The type copy is at page number 30. Or lordship, the original copy is at page number 30.
and number 26.
Yes, otherwise it's a 26. Signature is at 29 and the original signature is 36. Here. That is why the records were called for to examine this.
All right. Legal services. Yes, where is it?
Yes, it is at section 22E. The quorum is at 22B. The constitution of the permanent Lok Adalat. Establishment of permanent Lok Adalat, notwithstanding anything contained in section 19, the central authority as the case may be, every state authority shall by notification establish permanent Lok Adalat at such places and for exercising such jurisdiction in respect of one or more public utility services and for such areas as may be specified in notification. Every permanent Lok Adalat established for an area notified in subsection 1 shall consist of a person who has been a district judge or an additional district judge or has held judicial office higher in rank than that of a district judge shall be the chairman of the permanent Lok Adalat, and 2 other persons having adequate experience in public utility service to be nominated by the central government, or as the case may be the state government on the recommendation of the central authority, or as the case may be the state authority. And your lordship, the judgment ordered at that it is at 22E, your lord. 22E subsection 3. The award made by the permanent Lok Adalat under this act shall be by a majority of the persons constituting the permanent Lok Adalat.
My lord, I am paying for son number 2, my lord, through as a legal aid counsel, my lord. That son of the petitioner has died because of electrocution death, my lord. They admitted, my lord. The state legal service authority as well as electrical inspector also filed an affidavit. But whether that I
Yes,
acquired from
then
the
if that be so, why you are not paying the 4 lakhs?
No, that
You always pay that
that,
4
that
lakhs.
is
Why you are
so
on
4
all
lakhs,
this
your
thing?
lordship, 4 lakhs we can pay. That will be a separate bill.
And
But
that too, that is so, then he is otherwise also entitled to this 4 lakhs
My lord,
plus
there-
interest from the date of the occurrence
Here-
as per your own memorandum.
No, here is we can pay the 4 lakhs. That will be a separate claim. But this is an order, your lordship. It's an order which is passed without jurisdiction.
Understood, whatever may be. But
He
then
might
also
have
why
a
you are
claim,
not.
lordship. He might have a claim. We'll examine that claim. If he's entitled under the notification and the regulations, we'll pay.
There is a electrical accident report
Yes, there is electrical.
which
accident.
says that APTCL is liable.
Yes.
So under such circumstances, why you are not doing all these things? Make the payment out there. Matter ends out the 4 lakhs. It is 5 lakhs here which has been directed to be paid. Make the payment
Lordship,
of 4 lakhs.
Then set aside this order and then direct us to pay. We'll make the payment.
Then he files another writ petition.
No, lordship, we set aside this order and direct us to pay under consider his case under his regulations. We'll do it, your lordship. The
my
only
lord,
thing
even
is that-
otherwise, my lord, some technical ground I have inquired from the lawyer concerned that
Yeah, I mean, Mr.
Teacher, my
Pakatani, I
lord.
appreciate one thing.
he said that my
This
lord,
is a matter pertaining to which year?
2016.
2012.
Oh.
So, see, you have to take note of this. The matter has been pending for all this while unnecessarily. Yes, the jurisdiction is not there.
Yes.
The records also said that you have duly participated. Why have you participated out there? Why didn't you point it out at that point of time? Look here, all along, the chairman has been passing orders.
The chairman has been passing.
Then-
But I'm confined to what is there in the petition, your lordship.
my lord,
Just
whether
before
it
my
is a
time.
technicality, my lord,
Please the matter again on 22nd of August 2022. 23, on which date Mr. KP Pathak appearing on behalf of the APTCL shall take instructions as to take instructions from the APTCL take instructions from the petitioner company as to whether the petitioner would be entitled to the compensation in terms with the memorandum dated,
Lordship is the regulations of 2017.
the regulations of 2017. And regulations of 2017. This is the
Date, my
only
lord,
way.
date is-
Mr. Chaudhary, kindly appreciate. If I have to set this aside, I will have to send. Instead of that, here the amount is 5 lakhs. They are already paying normally 4 lakhs plus interest from the date of the incident. We may not go.
I'm agreeable with that, my lord. It matter may dispose of, my lord, today.
Not.
Otherwise, my lord, it
It will,
will.
you don't worry, this will be taken. This, taking into account that the matter has been extensively heard, this the matter as shown as part of
Date, my lord, kindly.
22nd. You get the order on that. Because otherwise this court has to set aside. But this will entail again another form of repetition. May not be proper.
My lord, even otherwise also the victim compensation
That
act.
is what I say. I told him that is why a person dies, it is 4 lakhs.
4 lakhs.
And the interest is otherwise accrued from so and so. But you just take the instruction as to whether you are ready, because otherwise the amount will go very high.
My lord, I have already got like 50% of the amount.
You have got,
50% of the amount.
so only 2,50,000 is
Yes,
there.
I-
Just get it.
Oblige.
Item number 14 to 37 and 41, 40 and 41.
Records to Kunpita.
My lord,
This is by one common judgment.
Yes.
So they have given 60,000. How much initially it was paid?
20.
Eh?
20.
That is
Per
by-
katha. Now it has been made 60,000.
No, my lord.
On the basis of what?
On the basis of earlier judgment matter.
Not earlier judgment. Here he says about some deeds. He's the absolute owner. He has received a
But I
copy
tried
of the
to take up the
notice. Kindly see here. Of the judgment out here that they are ready.
My lord.
But after hearing that the collector decided to award a compensation of 1,42,000 per bigha in lieu of the state land and paid the state of the state compensation money that required as so and so. He said the market value of the land was more than 4 lakhs and now so and so. The potential of the required land is extremely high as many important government lands, and apart from that, at the time of acquisition, even the office of the authority school colleges was there. So the compensation paid by the collector was not eligible. The delivery of possession of the claimed is 4 lakhs per bigha as the compensation. The deed of sale dated demand clearly showed similarly situated lands have been exhibited as reference numbers and other analogous. Not only that, similar cases of similar have been acquired under the land of the similar on the same market value of the Where is the sale lead? Yes, madam, where is the sale lead? Where do I get the sale lead? Where is the sale deed?
My lord,
And who is appearing for deputy commissioner? You have acquired the land. What is the value of the land? It is your duty. What do you want? Why do you need a record? You are not prepared. Huh? That day Mr. Bhattacharjee was appearing. Where is he? He was very anxious to do the matter that day. Where is he? তুমি মোৰ record খিনি চাও আৰু কোনোবা ফাইলত আছে চাগে.
Can I indicate to you, Lord?
Yes, please.
Item number 41, there is one record, LA Appeal 13 of 2023.
It is 41 নি.
But, my lord, if
This
you-
is item LA appeal.
13 of 2000.
এইটো কোনটো 13 নি. এইটো কি মানে LA appeal টো এইটো ক'ৰ পায়?
basically,
LA appeal number তাৰ নেকি record? আৰু কিবা আছে নি record?
Lord, the main record pertain to LA Appeal 6 of 2023. Lord. One filed by Kased Ali, in which, Lord, the evidence had been submitted.
Where? Saket Ali.
Kased Ali.
আছে নি instruction Saket Ali.
That is item 32, but there is no record. What has happened, Lord, if your lordship could see the record of item 41, it shows that similar order has been passed as in reference case number 55 of 2001.
Hmm.
And reference case 55 of 2001 is by Kased Ali. And there, Lord, he has filed the evidence.
Saket Ali, that matter is not there.
Yes, it's there, my lord, at
Item number
32,
Kased Ali.
Kased Ali.
Instruction LA appeal 6.
But I could not find the record there in that.
Kotu record নাই নি? Yes, madam, what is your basis of asking for more compensation?
My lord, because my lord, initially I was given only 20,000 per bigha, my lord, by the collector, my lord. Then, no, not per car. Per bigha, my lord. Total, my lord, 1 lakh something with the interest was paid, my lord, by the collector. Thereafter, my lord, we had filed application under 18 of this act, Land Acquisition Act. And then, my lord, we had my lord, we have adduced the evidences, my lord. And that time also, it was beforehand, my lord, it was already in amalgamated, all the cases were amalgamated because acquisition.
Madam, you are asking for higher amount.
Yes, my lord,
Why?
because my lord, the potentiality of the
Fantastic.
locality, yes, my lord.
So what is the land value?
At that time, my lord.
Yeah.
At
It has
that,
to be taken, this is done under 1894.
yes, my
So
lord.
it has to be as on the date on which the notification under section 4 was issued.
Yes, yes, my lord.
Now this has to be done on the basis of section 23,
Yes, my lord.
wherein 23(1) categorically says that the land value has to be taken as on the date on which the notification under section 4 was issued.
Yes, my lord. We had-
Section 4 notification was issued when?
96, my lord.
90?
96, yes.
96?
Yes.
Okay. Now show me, what is the document you have produced
Still is,
saying
my
that
lord.
this is the land, this is the nearby land, this is the value?
There's a one sale deed, my
Where
lord.
is that?
My lord, definitely with the Kased Ali, my lord. Reference case number 55, my lord. The Kased Ali had adduced evidences, my lord. Affidavit has been filed. Along with that, we had exhibited that, my.
So you don't have the document?
Uh,
Are you not appealing for Kased Ali?
yes, I was.
You
appearing
must
for
be
this.
having that document.
Yes, my lord. Now at this moment, I couldn't because it's so old, my lord, the cases. And it has been scattered everywhere, my lord. And he was also directed, my lord.
Madam, are you not interested in getting a higher compensation?
Yes, yes, I am.
Then it
interested, my
seems you
lord.
are not interested.
No, my lord, no, no.
Why
no,
should
my-
this court take the pain of taking up these matters? Then
My lord,
other
my lord,
matters will take
I'm
it.
so sorry, my lord.
Not
I'm so sorry.
necessary. It seems that you are, I'm
My
recording it,
document-
that the petitioner counsel is not bothered about this matter, delaying.
lord.
He's enjoying a stay. So
Well, I'm so sorry, my lord.
then your counsel who was appearing on the last occasion knew it that this matter would be taken up today.
Yes, my lord.
Then why you are not prepared with your matter?
My lord, that document I could not find, my
The
lord.
document
I
it
don't
means
know.
there's no records of that. Then
Record,
on
my
what
lord,
basis it should be increased?
Kased Ali,
We dismiss, we allow all the appeals. There's no materials on record. We
my
allow all
lord,
the
in
appeals and
Kased
then,
Ali's case, my lord,
no, we're allowing all the appeals.
my lord,
There's
then,
nothing on record. on the basis on which one can find out.
My lord, LCR of Qasid Ali, my lord, has not been received, my lord. That has not been called for, I think, my lord. Qasid Ali is 55, my lord. If there, my lord, everything was there. Reference case number 55, my lord. And he was supposed to file affidavit on Qasid Ali's evidences, my lord. For 7 months, he has not filed, my lord. Because there is a.
Madam, kindly don't blame him. It
No,
is your
I'm
fault.
not blaming him, my
No,
lord.
no, if you are representing Qasid Ali, why couldn't you get me the lower court record for that? Forget about this record. Why haven't you been able to just produce this evidence on affidavit out there?
But I have a certified copy of the evidence.
When I later. Okay. Appeal to admit you one. What is all this?
My lord, the half payment has also not been, my lord, amount has not.
They
been
should not
paid.
pay you half what 5% also you are not entitled to. Is this the manner in which you are conducting your cases?
I'm so sorry, man.
Mr. Dubey will take up after some time. Just find out from you and your junior which are the appeals which have not been appealed. Now this Qasid Ali has not yet been admitted. Just find out. I'll pass an order for admission of the appeals. Now none of these appeals have been admitted. This one also, look here. Records have not come.
But there's a common order in one of the appeals, my lord, admitting all series of appeals. I'll check, my lord.
How can it be so?
No, my lord. It was listed along with, my lord.
No, there is no order out there.
Lord,
What is Qasid Ali's number?
Qasid Ali is 6 of 2020.
6 of?
2023.
It reveals from 36, 2017, 53, 56, 15, 14, 15, 22, so and so are not admitted. Appeal number 14, 15, so and so are admitted for hearing. List all these appeals. Here, you see, Justice Manish Chaudhary has passed an order. If the examination in chief of the prosecution witness number 1, Mohammad Qasid Ali, is available with any of the parties are at liberty to bring the same on record by way of an additional affidavit. This order was passed on 13/3/2023. Until now, nothing has been done. Everywhere. See, another order. In the event of the learned counsel, so and so shall make an endeavor to produce the examination in chief of the prosecution with who has adduced evidence, so and so. In the event of any default, the parties to produce so and so here. And which court has passed all these orders? Doesn't matter. It's in Kamrup. And from there, the records have not been called for. Simple order, there should have been that call for the records of that case. Matter ends. You also don't have the records.
I have only the copy. I have obtained a certified copy.
Now, do you have the document, the sale deed?
No, madam.
We set aside those orders then. set aside this and direct the authorities to further decide as per law. This has not been done properly. First, madam, tell me what is the basis of arriving at 60,000? You are appearing for the respondents.
Yes.
What is the basis of arriving at 60,000?
Only the sale deed, my lord.
Huh?
Sale deed and the evidence of.
What does the
custody-
sale deed say? 4 lakh per bigha,
No, my lord.
per katha.
Yeah, 60,000, nearly 60,000 per
Where?
katha, my lord.
Where are you finding that? Because
Upon
here the court says something else. Here it says that, see, here he said, he had claimed rupees 4 lakhs per bigha as compensation on the acquired land. The sale deed number so and so, showing similarly situated land have already been exhibited in reference case number so and so, so and so, so and so. And other analogous already disposed of so and so, meaning thereby it is 80,000.
Yes, my lord.
If it is 80,000, how does the authority come into, or the reference code come into the figure of 60,000? What is the basis?
Only on the potentiality of the land, my lord, the locality, my lord.
Has he discussed?
My lord,
Has he discussed?
my lord, the evidence has been discussed.
Madam,
my lord.
have you gone through the order?
Yes, my lord.
See, I'll come to paragraph 14. Paragraph 13. I think a Munsi will pass a better order than this. Well, pass it. A first entrant will pass a better order. This is the manner in which a reference court passes an order. These reference codes are being given to the district judge's level, taking into account that this is a finality reached.
But at para 12, my lord, evidence has been discussed, my lord.
What is discussed?
At para 12, my lord.
Show me what is discussed. There's nothing.
PW1, Muhammad
The
Qasid
market
Ali.
value of the acquired land of the Pattadas mentioned in the aforesaid were almost more than rupees 4 lakh at the time of acquisition, and the date of possession is also similar to the date of possession of his land. As the claim of all Pattadas are similar to his claim, he has authorized to give evidence on their behalf in all cases.
My lord,
He had
I'm sorry
exhibited
to
some
interrupt, my
document.
lord.
Exhibit 1 is the certified copy of the judgment and order dated demand passed by the so and so. And exhibit 2 is also the certified copy of the judgment and order passed by the same competitor. Opposite party did not cross-examine the petitioner as regards the filing of so and so. From the evidence on record, I am of the opinion that the collector had not adopted a standard while assuming the value of the acquired land. I therefore hold that the assessment at rupees 1 lakh per katha bigha, that is 20,000 per katha of the acquired land, was not fair, reasonable, and adequate. I have gone through the evidence on record. I find that the land acquired in the instant case is more valuable. Considering the evidence as on record as well as the submission of the demand for both sides, I hold that the claimants are entitled to get compensation at the rate of 60,000. What is the basis? Can this be the basis? You have given a document which shows 80,000. What is the basis of the court below to say it to be 60,000? And madam, as per the Land Acquisition Act, even you can produce a certified copy of the deed of sale. If you were anxious enough, you could have very well got a certified copy out there. Why haven't you got that certified copy and produced it before this court, which was there?
I'll do that, my lord. I'm sorry, I may be given an opportunity, my. I'll do that.
I'm not interested out there. এই record যোনকেইটা appeal হৈছে নে, যোনকেইটা appeal admit হোৱা নাই, পুৰা appeal admit কৰিবি। The registry is directed to call for the records of Which case?
Reference case number 55, 2001, my lord.
What?
This
LA
is
case number?
LA case number, LA appeal number 6 of
LA appeal number
2023.
6 of the
No, 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 no.
2023.
Where is that? Trial
Reference
court.
case 55 of 2001.
Record of
Three.
reference case number 55 of 2001
One, yes, ma'am.
from the court of the
Additional district.
additional district judge.
Now it is
Come,
not,
one
not fast
Kamrup.
track, my lord, not fast
No, no,
track,
number 1 Kamrup.
number one.
Kamrup Metro.
Not number one, my lord, this was from FTC number 3, now 3, now 2.
Additional district judge number 1 Kamrup is the
No,
From the,
no. This
the
record will
registry
be
is
visible
directed
only
to
there.
call for the records of reference case number 55 oblique 2021,
2000,
which is lying
2001.
2001.
2001, lying in the office of the court of the additional district judge number 1 Kamrup Metro at Guwahati. Taking into account that the acquisition proceedings was of the year 1997 and the claimants have been fighting, have been pursuing the litigations for more than a decade, more than two decades. This court directs the registry to forthwith call for the records so that this court can take up this matter again on 17th of August 2023. Full stop. This court, however, expresses great displeasure at the conduct of the respondent counsel for the purpose of not preparing this matter.
My lord, it may be, my lord, FTC 3, my lord, not 1, my lord.
1.
What?
Additional district, no.
Order is passed by additional judge number 1.
But
We
this
had
will be
filed
there,
that
no?
court, but the matter was taken up. Certified copy to stop.
खाली जोन किता appealot admit हुआ ना appeal admit कोई the said appeal shall be taken up for final disposal on the next day. Mr. H. Sharma, you are appearing? Be appear and also get your instructions on this. On what basis? Get the instruction from the Deputy Commissioner. On what basis did he arrive at this 20,000? Mr. H. Sharma, appearing on behalf of the Deputy Commissioner Kamrup Metro, shall also apprise this court on what basis the compensation was fixed at 20,000 per katha in respect to the land acquired in LA case number
2795,
of
my lord.
1995.
27/1995. This direction is so issued taking into account that it is the burden upon the collector in view of the judgment of the Supreme Court in so and so redeem to place before the court, reference court, the basis on which the compensation was fixed. Mr. Sharma, you be there. The registry shall also show the name of Mr. H. Sharma as a learned counsel appearing for the Deputy Commissioner. For the collector, Kamrup.
Number 38.
Made legal.
Oh, stop admit ko adi wala. Jun go admit ko na. Ini ko de fun rakhi no ho.
This case, your
Yes, what is your case?
petitioner is aggrieved by the order of the learned district judge whereby an amount of rupees 3 lakh has been fixed as compensation for surplus damage that is being caused to the land of the petitioner before the installation of powerful 400 kV electric line.
A read in the nature of sorcery should not be issued for setting aside the impugn order passed by the learned district judge Hailakandi in Swain. Give adequate compensation to the petitioner to the tune of rupees 81 lakhs. Okay. How much he has given? Huh?
3 lakhs.
This is done. You are only taken the right of the use, na?
Right
Not right of use.
Not right of.
Under on top.
on the top.
Now what, let's see what is the order says.
The impugned order is at page number 49, your lordship. And relevant, because ultimately it starts from page 49.
What is the basis of coming to that finding? The evidence of they has claim for constructing brick falling road in the point to get incurred and constructing. As the records come there. Purchase of land, but these facts of incurring expense have not been. Yes, why are you agreed?
Lordship, this amount has been fixed at page 57, your lordship.
3 lakh.
The paper submitted by the Power Grid also shows that compensation of rupees 30,000 was assessed for damage of Devra and Petty in respect of the land of the petitioner. In view of the above discussion of the materials available in record and having considered the report submitted exhibited in the case by the petitioner, it reveals that the petitioner is entitled to get compensation from the Power Grid company for causing surface damage within the line corridor, such as damage caused to the chimney of the crane, etc. Both the issues are decided accordingly. In view of the discussions and findings of the following issues, according to me, compensation of an amount of rupees 3 lakh would be appropriate and reasonable for surface damage, and the petitioner is entitled to get the said amount allotted. This is how amount of compensation has been fixed. What happened, your lordship? The plot of land over which this powerful electric line has crossed, it is a 400 kV powerful electric line, your lordship. It crossed over the brick clean industry that was set up by the petitioner in the year 2007. On 18/7/2007, he got the NOC from the district office, and thereafter he has set up the brick industry. In 2011, when the process was initiated that they wanted to erect powerful electric lines, they immediately made a complaint to the deputy commissioner that you either shift the alignment to some other site, or otherwise my chimney, he has installed some chimneys also. The chimneys will be affected, and there are labor quarters and some buildings. Because some labor quarters are made of bamboo, the powerful electric line shows there is a risk to their lives also. So he made, lordship, I'll take your lordship to the annexure that will clarify the issues. Page number 12, first your lordship will see. Page 12. The NOC that was issued by the deputy commissioner way back in 2007 for setting up the bricklaying industry. Seen the petition dated so and so filed by Mahiruddin Chaudhary, son of so and so, praying for issue of NOC to start a bricklaying industry. Also seen and perused the report submitted by the circle officer Algapur on the above petition by his letter. So now it is satisfied that there is no objection from this and for setting up a bricklaying industry.
So you set up your bricklaying industry.
I set up your lordship. In the year 2011, the process was initiated.
When did you set up?
2007.
So you must be having some license.
Yes, your lordship.
Where's the license?
License, though I have not an expert, there is no dispute as to this, your lordship.
No, when did they start the proposal?
In the year 2011, at that time I made a
So
representation.
you had the license at that point of time to run the brick kiln?
When it's instructed to that, but
That is an important thing. You see, your damages has to be taken on that basis that you were a running industry or not. Or did you construct it at the time when or started at the time when the line was supposed
there
to
was
be?
a direction from the deputy commissioner to the circle officer to conduct an inquiry. He has also submitted a court inquiry report that is also there.
What is that? That you were running?
Running.
But when?
Lordship will see page number 13. The first objection that he has
Let
made.
us see your evidence.
Evidence, Lordship will start. I have also an act. The inquiry report, Lordship, may kindly peruse for a moment.
Wait. No teeth of look. reference to, this is in 2012.
2012.
And why not to state that I have physically verified and like to report that it is a fact that the alignment of high tension line and the chimney is approximately 120 feet high. And if the high tension line is allowed to go in the present alignment, then both will intersect at 65. During my preparation, Sri Moyuddin, the petitioner, had submitted a few copies of the petition and going to this scheme to the petitioner, checking the proposed alignment in beginning. But his prayers were unheard. Presently, he, after taking notes. So, you see, to solve the above problem, I am of the opinion that either the chimney be removed from the place or the alignment of the high tension line be removed. Maybe there is something or the parallel with the chimney, the high tension line. Yes, then
Your lordship,
what is this newspaper?
for report. Report to the direction of flying.
What time? No. You can understand.
Their initial stand was that I am not entitled to any compensation whatsoever. And without paying compensation, they erected the high voltage power line. Your lordship. Thereafter,
0 to peak scaling load. You filed a suit also. Huh? There's a suit?
I filed this application under section 10 DP portal.
Rahimuddin Borbhuiya versus Chief Manager Parson Iman. Rahimuddin Borbhuiya versus so in the court of and request to appear before
Okay.
What document did you give to substantiate your claim? Nothing. No evidence. What is that?
That is,
That is what I was looking in the entire file. Not a single piece of evidence. How do you do it? Tell me.
the fact is that, your lordship, there was a particular industry that was set up.
Understood, but if you want to claim something, are you not going to substantiate it with something? How do you do it?
It ought to have been done, your lordship. It ought to have-
You have to show that this was the amount I was using. This is the amount I was getting. This is the amount of sale which has happened. And this has been stopped. Something to that effect. How do this court? You have not, you are claiming how much? On the basis of the road construction, you are claiming some 22 lakhs. No, you have not produced any document. You are saying that for 3,500 brick chimney, you are claiming this amount. How do you make the basis for that? You do one thing, have a look at the records. We'll take it on some other day. Have a look at the records if you find anything. I couldn't find anything out here. Nothing is there. If nothing is there, how do I interfere?
When otherwise, lordship, the amount.
I understand you have, you see, you are on this Livisha or Lavisha or that judgment, na? There wherein it says it also you are entitled. But the thing is, if you are entitled to, you are to show something, na? This is what has happened. Now you are to show, yes, one thing is very true. This area which has been taken, there has to be a compensation because can you use it or not? Isn't it?
Diminishing value of the land.
You just think on that and then you place it so that I can remand the matter back and you can come up with some evidence to that effect. Because this aspect, that this area where this high tension wire is going and this area, by this particular area, you cannot do anything. Obviously you can't because these are 440 voltage kV line. So you can't do anything. So this area had to be acquired. And if this is acquired, first the area which has been acquired, and what is the impact upon that on the other authority? So this, have a look. You have not mentioned anything to the effect. So if you have not, you have undergone into this brick and all these things, which may not be so good. The Lavisha says, if I am not wrong, said that this area also you are entitled to.
Correct.
Isn't it? So therefore, in fact, there was another matter pertaining to Tejpur where they were not giving. And there's a court, the order passed by this court, by Justice P. Deka, holding that he is not entitled to this. So when the matter, some other matter came before me, I taking into account this Lavisha's judgment. I said that that judgment is per incuriam and therefore directed the authorities to again look into it and pass orders.
The order which has attained finality earlier by.
No, that order is there, that I couldn't touch. The other matter which came before me. So thereby I remanded for taking into account that aspect. Look into that. If you can make out a case on this aspect, I can remand it back so that you can give something out there. Because obviously one thing, Mr. Das, if the 440 kV line goes above his land, that land either has to be acquired. You can't have it that I'm having this land.
Under the Act, my lord, we are not required to acquire the land, my lord.
Then how
Only
do you?
You are to pay compensation for this causing surface damage only, my lord.
That is a surface damage which is being caused. Because this person cannot use this land.
No,
He
they
can't
are
use
using it is a big pretty, my lord. Actually, from the evidence, my lord, at page 40 and 48, my lord, you lords will find. In cross examination, my lord, of his witness, my lord, PW4, my lord. I was ordered by ASO by Algapur Circle to make an inquiry to the concerned place, and accordingly I submitted the report before the ASO to that effect. During my inquiry, I found trees, etc., but I did not mention about the same in my report. During inquiry, I found that the electric wire were already drawn by about 25 meters above from the earth. I found that this chimney broken on the top. I cannot say how much amount of money is required for construction of this chimney, my lord. This is the only evidence, my lord. Their evidence, my lord. And next line, the big industry was not in a running condition, my lord.
When he visited,
And if it was not done.
he
Yeah.
visited later on.
Oh, maybe, my lord.
Then
Report is, my lord.
he
9
further
to-
says that
report
I
is that,
found that the
9
site
to the-
some unbaked as
Well.
well as some baked, unbaked bricks.
Well.
When I visited the site, I made assessment of the damages in a lump sum way. I cannot say whether any civil engineer submitted any report to the effect of some concern. No, the fact that this particular under that 440 high power transmission line, you can not do anything.
Right.
That is true. You can't have any other say. If you can't do anything, how much impact does it cause to so and so? You argue on that point. Huh? Have a look at the records, but the records are very disappointing.
When I could not get much record
Eh?
that he has made available to me, I also could not find as the.
Yeah.
But
So
ultimately
that is very what he is asked. Obviously, the court was right on that. So on the applying Lavisha and my other, that is the judgment of Northeast Transmission. Forgot the name. So there I held that the judgment was per incuriam and then remanded the matter back.
Even otherwise, this
I
amount.
think it is reported somewhere.
I'll find out.
Find out. And then on the basis of Lavisha, because Lavisha says that particular area you have to.
Yes, and it is also common that such powerful electric lines, if goes your lordship, how can one use this land?
One can never with a 440.
Even the very purpose for which the land was supposed, it cannot be used for anywhere also. It may be going in such a way that you cannot use the whole land.
In fact, they are not, but APTCL and all, when they carry out the lines out there, they pay compensation for the land. They acquire that portion of the land.
Actually, it should be done. And their case initially was that I am not entitled to any compensation since they are not acquiring my land. So initially, they did not give any compensation.
Okay.
Okay. I'll try to find out that judgment.
Mr.
MH Kaskar.
M.H. Laskar, the learned counsel appearing on behalf of the petitioner, submits that he would like to go through the evidence, through the records before arguing the matter. Taking into account the above, list the matter again on 24th of August 2023.
I'm obliged.
39.
Yes, what are you challenging?
My lord, we are challenging the constitution of the Boruland Territorial Council.
Huh?
Boruland, the constitution, the inclusion of the members in the council, my lord, that is primarily under challenge.
How?
Lord, there is a procedure prescribed under the BTR rules, my lord. Boruland Territorial Council election rules, my lord, that procedure they have violated.
You are challenging the constitution.
My lord, the prayer, my lord, may be pleased to find. The page, my lord, starts at page 24.
Page
24 is our prayer part.
What is this 13/12/2020?
My lord, may be pleased to find. This is that, my lord, page 97.
Swearing in of the chief executive member
My lord.
and then Pramod Poro, newly elected so-and-so, allowing them to form the executive member. All the above letters were handed over. Honorable Governor had then
Then, my lord, the other prayers are also there, my lord. The 14-12 is also under challenge, my lord. 14-12 is at the next page, my lord. Page 100, my lord. Within a span of 3 days, my lord, all arrangements have been made, my lord, so that the rule prescribed otherwise. The BTR rules, my lord. My lord, may I pray, my lord? My lord, maybe please to take up on Thursday, my lord, as in the top of the list, my lord. It would take some time.
Understood, but this court is not, you have not made this court interested to take up the matter.
My
Give
lord,
me something, some
lord,
juice,
my
so
lord.
that I can fix an early date.
My lord, on that day, my lord, perhaps I can, my
Why
lord,
should I? There is otherwise so much in the list. Why should I?
my lord.
It
Last
is
time,
happily running, PTC is running,
my lord. My lord, something which is prescribed by the,
unless
my
you give me something
yes, yes,
that
my lord.
yes, something requires to be done. I
My
will hear and then fix it. Just in the other matter, I have fixed it.
yes, yes, my lord.
But you have to give me something. There's no
My
juice
lord,
out there. Why should I?
no, my lord, in our case, my lord, we have specifically stated, based on the rules, my lord, that the BTR rules prescribe the due procedure that after the election, in what manner the council is required to be constituted. Starting from Rule 68 to Rule 90, my lord, all the provision of the prescription had been violated by His Excellency Governor. That is the issue, my lord, the main fact. My lord, in a fastest manner, so hurriedly it has been done. My lord, we were the members, my lord, of the Boruland PTC party, my lord, and we were out of 17. We came out successful out of 40, my lord. Once we,
Huh?
out of 40 seats, my lord, we won 17, my lord. The,
You were 17.
17, 1-7, my lord,
Ah.
17. Now, my lord, we presented that we being the majority, we should be given the scope to form the council, my lord. But
40, how can you be majority with
no, my
70?
lord, the rest of the parties, my lord, if we segregated, my lord, then they come, my lord, in minority in comparison to us, my lord. The UPPL and the other party club together, then they become my lord,
So the first offer should be given to you.
first offer should be given to us, my lord. That has not been, my lord, done by the honorable governor, my lord.
So the offer was given to the other
Parties,
the
my lord.
post alliance,
Post alliance, my lord.
post,
After the
post
election.
election alliance,
Yes, yes, my lord. After,
not to the largest party.
not to the largest party.
But that is the challenge.
That is the one ground, my lord, one contention. Secondly, my lord, in Rule 68, my lord, it is the prescription of the, my lord, statute that all the members who have been elected should be gazetely notified. There should be a gazette notification for all the members. After the gazette notification is done, my lord, then the rest of the procedure for the constitution of the CEM or the chairman or the vice chairman will come up, my lord. But by bypassing all these provisions, my lord, they have constituted the council, my lord, only to deprive us in a very hurried manner, my lord.
But have they now post facto done it?
My lord, now they are running, my lord, because this,
No, no, in the post facto, have they done it?
no, it has not been done. Even in their affidavit, my lord, they have not touched all these vital law points, my lord. They have just in our specific paragraph, my lord, where we have mentioned categorically the violation of the rule. They have not denied or they have not, my lord, specifically, categorically, my lord, put substantiated how and under what provision of the power they could do this. My lord. That is the issue, my lord.
So your case is that they have usurped the jurisdiction
Exactly, jurisdiction of the statutory prescription, my lord.
as well as also your right to
Our
be.
right being a majority in the at that relevant period of time.
Now what happens?
Now, my lord, they are running, my lord. If I succeed, my lord,
Now
my lord,
the governor, let's aside your petition is okay.
my lord.
Now the governor has, can the governor say no that to remove it?
Because my lord, the governor, directly the governor has not entertained this, my lord, done this. The authority on behalf of the governor has done this, the secretary and the commissioner, my lord. Now, if that,
Who can remove them now?
my lordship, my lord, if interference with the, my lord, impugn order, my lord, if we can, my lord, with our, my lord, pleadings or by submission, if I can satisfy my lord, then my lord can interfere with the impugn orders also.
Then you are going to say that
My
this
lord.
court also said have to direct that the largest party needs to be called.
That, my lord, because that is the discretion of the, my lord, that part will come later on, my lord. But initially, if the council goes, my lord, if the council is not formed in accordance with the law, my lord, with my limited knowledge, my lord, what I am respectfully submitting, my lord, we are governed by the rule of the law. Now, for the every purpose, my lord, there is the rule of the law and the prescription is there, my lord. Whether the governor, sitting in his own capacity, my lord, can supersede this power, my lord, the PTR rules, which is an statutory prescription and gazette notified rules, my lord. Whether he can exceed that jurisdiction of the rule, my lord can decide that also, my lord. The serious consequences is there, my lord. I can understand.
Hmm?
My lord, if this council goes, my lord, then a new council is required to be constituted. Sorry, my lord, in accordance with the prescription of the law, my lord.
Where is the notification in the rule?
My lord, the rule starts, my lord, may be pleased to find is at page 43, my lord.
Hmm.
Page
Wherein
43,
you
my
are
lord, the
referring to
Boruland-
which one?
My lord, the Boruland Territorial Council Election Rules 2004, it is published in the Assam Extraordinary Gazette on 30th of December 2004. At page 43, I am referring. my lord.
You are
Annexure C.
referring to, yes,
My lord.
which one you are referring
My
to?
lord, if my lord may straight
Which are the violation which has happened?
Yes, my lord. My lord may straight away can come to rule 68, my lord.
Returning officer.
No, my lord, the rule 68. Yes, my lord. Yes. The returning officer shall immediately after completion of the counting and signing of the result sheet in Form 19, declared in Form 20, the candidate securing the largest number of valid votes to be elected under Section 5, read with Section 12 of the Act, and hung up the same in his office and sent signed copies thereof the election authority and the government shall cause the names of the elected candidates published in the official gazette. Till date, my lord, there is no publication in the official gazette, my lord, and that part they have also not denied. In
How
the,
is
my
it
lord,
relevant for your case?
my lord, relevant because this is also a prescription of the law, my lord. Once this gazette notification is not done, my lord, then there is a primarily.
So are you saying that
My lord.
as of now, if
My lord.
that is not being given,
My lord,
so none can be deemed to have been elected till now
No,
because the returning officer has not given the what do you call
exact notification.
as per the representation of People's Act,
Exactly,
has
my lord.
not given the certificate.
Exactly, my lord. Exactly, because this gazette notification will be the ultimate document certifying that a person.
So
has
under
been
such
elected.
circumstances, you have also not got it. You are one of
My
the
lord,
contenders.
Yes, my lord. For
So
us,
as of now, you are also not one of the members of the
election of the council, my lord.
council because there is no certificate.
No certificate. Same consequences will follow to them, my lord. So without the certificate, they
Then-
cannot become, my lord.
But anyway,
My lord.
if the court directs out there that okay, give the certificate,
My lord.
then the consequences will follow. But
My lord,
what about the others?
My lord, others are, my lord, rule 89. My lord may be pleased to find. The rule 89 is the, my lord, election of the chairman.
Hmm. Will
At
be held
page
within 15
75.
days from the date of publication of the result of the election under Rule 60,
My lord.
when the government may extend the period of will be decided to by the court. Now, what is not so you say that 68 having not been complied with,
My lord.
you can't go to pay
Rule
89.
89. My lord.
That's it.
Prescription of the law, my lord. Rule 89 is also there. Rule 90 is also being violated. My lord, at rule 90 is at page 76. my lord. An elected member present may propose an elected member for the office of the chairman. Such situation has never arisen, my lord. Because we were no
May
person has
shall
been
be
communicated.
seconded by another election. So you say that a person can be deemed to be elected only after the compliance to 68.
My lord. This is the, my lord, this is
So
my
if 68 has not been complied with, you
My-
can't go to 89, 90.
89 and 90, my lord.
And accordingly, the actions becomes bad.
That in law, my lord.
So the governor cannot supersede you.
No,
So that's your case.
that's my case.
Yes,
The other issues are also there, my lord. Those will.
yes, Mr. Bora.
Not to fix it any other day, my lord.
Why?
Today, but difficulty is that, my lord.
You, at your request, I think.
My lord, that can be, my lord. That, but my lord, today, my lord, the difficulty on my part, my lord.
No, tell me
That's
whether
what-
you have complied with 68.
I'll get all the instruction, my lord, because here
Are you saying that this petition was filed in the year 2020
My lord,
and till now you have no instructions on 68 when the petitioner specific cases of 68?
I will get the entire instruction, my lord. Late.
What?
Because
Are you saying that as of now, there's no certificate of election by the returning officer?
because I have to inquire all the facts, my lord, now, because this issue has come up now. Certificate, etc. Because council was running from 2000, my lord, till there, till date, my lord. And it is running with
Because if
with
somebody
with
wins the
majority, my lord.
election, there has to be a certificate issue.
Not true.
How is it possible that you don't know that 68 has been complied with or not? Are you saying that none of the members who have contested and won the
Most will
election
they-
out there, they have not been certified till now?
They
Because
should have-
unless the certification is not there by the returning officer, how can they be deemed to be elected?
my lord, since they are, the council is running, his certificate is there, I think, my lord. Let me get a follow with a particular instruction, my lord. Because it cannot be without this certificate, the council is running for last more than 3 years.
So he has made a specific averment in his
Gazette
petition.
notification,
Gazette
certificate in the form of
What
gazette
gazette
notification.
Uh.
That is the prescription of the law. That if that gazette notification is not there, my lord, then that requirement has not been.
So rest goes for,
That goes-
the consequences will follow.
Consequences will follow, my lord. That's my limited understanding.
The learned counsel appearing on behalf of the petitioner has submitted that though election was held to the, what is
My lord,
that?
The Boruland Territorial Council.
To the Boreal Territorial Council. But the mandate in terms with Rule 68 of the
Boruland Territorial Council election rules, page 43.
Boreal Territorial Council bracket election, like those rules 2004,
Mine.
have not been complied with. And it is the specific case of the petitioner that there has been no gazetted notification, which is required under Rule 68. The learned counsel for the petitioner further submits that as there is no gazetted notification, all steps so taken under Rule 89 and 90, as well as the other steps so taken by the governor of Assam, is contrary to the rule of law. Mr. S. Bora, the learned counsel appearing on behalf of the PTC,
But if I can interfere, my lord, the election commissioner is also party. It is the election commissioner will take it.
election is, they are not represented.
The representative, my lord.
Who?
My lord, I think it's him. Yes, my lord.
So, may not, he is not the, are you going to issue the returning officer? You are the returning officer, it come under your provision.
Yes.
Mr. S. Bora, the learned counsel appearing on behalf of the PTC, however, submits that he has no instructions as to whether there has been any compliance to Rule 68 of the Boreal Territorial Council bracket election rules 2004. Mr. Ardube, who appears on behalf of the State Election Commission, submit. What is it? Have you complied with 68? Further submits that although the petition has been filed in the year 2020, and even after a period of 3 years, has no instructions as regards the compliance to Rule 68 of the said rules. Mr. Rabba, you have anything to say?
I'm appealing for the.
No, you have anything to say?
Private, but my lord, in my affidavit, madam.
No, I'm asking you, has your notice been, has your election been notified?
In my view, my lord, it was done in accordance with
I'm asking you a specific question. Has your notification, has your election been notified in an government Assam Gazette? That I need to check. Mr. R. Rava, S.R. Rava appearing on behalf of the private respondents also seems to be not aware as to whether there has been, whether the election of the private respondents have been notified as is required under Rule 68 of the Rules of 2004. Taking into account that the respondent councils are not aware of the matter, though it has been filed as far back 3 years back. This court fixes this matter again on 22nd of August 2022-23. It is made clear that if the respondents are not aware, it does not obtain instructions in that regard, this court shall dispose of the petition on the basis of the available facts. See the juice.
My lord.
Yes, what is that?
I have found out that 6 of the appeals which have not been admitted. Item number 17, 18, 20, 21.
You give it to him.
Yes, thank you.
Let to registry because what is happening, Mr. Dubey, kindly appreciate. This delay
Yes.
is having a cascading effect on the, because in view of 28 and 30,
Yes, ma'am.
the amount will go huge.
Yes, yes. The interest burden is
Will go huge. Because I tell you, there was one client of mine. I told you that day,
yes, your lordship has indicated 4 crores and odd, my lord, was 40
4 crores, it was something like around, the initial acquisition cost was 18 crores 78 lakh. So I filed a reference case. Amount which was given by the reference court was around 70 crores. As of now, he has got, no, the reference court gave around 40 crores or something. On appeal, it was made 70 or 75 crores. Matter went to Supreme Court. As of now, he has got more than 110 crores. And he is about to get another 110 crores in view of the interest. Because it's 15%.
50% from the second year, my lord.
Huh?
From the second year.
From the second year.
Kalakatan.